Public, the chair calls the Omnibus Public Safety Criminal Justice Reform Conference Committee of the Senate and the House together. Not sure if I should say good morning or afternoon, depending on which clock I'm looking at. I think I'm going to play it safe, Senator Limmer, and just say good afternoon to everyone.
Good noon.
Good noon. There you go. Good noon.
Good day.
Members, today's and to the public, today's committee hearing is relatively straightforward and simple, but obviously the issues before us are big and complex, and so there's strong interest on the part of the Minnesota public, and so I do welcome everyone here, pro and con, on the issues before us. Your state government should always be transparent and open to you, and it's in that spirit in which this conversation will occur today. The presentation today actually pretty much concludes a series of presentations on the part of the House over the last roughly a week on those days when it's been the House's turn to have the gavel for this conference committee, in which we did a major, quick walkthrough of major provisions in the House Omnibus bill. I have to say, members, I'm quite proud of the House's bill, and I'm looking forward to our ongoing conversations with our Senate colleagues as we look to put together language from both bodies in agreement so that we can take back a strong bill to both our respective bodies for final passage. Today's bills are House File 8, House File 9, and House File 1115. House File 8 and 9 are firearm safety-related bills. House File 8 speaks to criminal background checks. House File 9 speaks to the extreme risk protection order. And House File 1115 is cooperative private divorce. The format that I'll be following today will not depart greatly from how we have been presenting in the past 3 or 4 hearings, which is basically centered on having a quick, concise, accurate presentation of the technical aspects of the bills before us. My intent then would be, this is a slight deviation, although we have had testifiers on previous bills, but we've really limited those on all the previous bills, because the intent here is simply to get the House language transparently before our Senate colleagues. So at some point when we're voting on any of these provisions, we're aware of what they are. So the format will be able to take these bills one at a time. We're going to have a quick, no more than 5-minute presentation of the bill. We will then hear a testimony from a individual opposed to the provision, followed by an individual in support of the provision. Those comments are expected, and I would request our 4, actually 6 testifiers to limit themselves to between 3 and 5 minutes. Following the pro and con of each of those bills, respectively, then we'll open it up for committee question and answer, very much like as we've done throughout the past week. When we're done with that, then we'll move on to the next bill and just continue that way until we finish the 3 bills. So with that, members, I will ask Representative Pinto to come forward to present House File 8, Firearm Transfer Criminal Background Checks Required. You'll find that on page 214 of the House bill. I'm not sure what page, and side by side, but page 214 of the House bill. And again, Representative Pinto, what I'm looking for is a accurate description of the bill. It's primarily it's technical information. Make your key points, and then once you're done, I will move on to Mr. Rob Dorff and the Minnesota Gun Rights to come forward and offer his 3 to 5 minutes of comments, and then Sheriff Tim Leslie of the Dakota County Sheriff to offer 3 to 5 minutes comments as well. So with that, Representative Pinto, House File 8.
Thank you, Mr. Chair, and members, and to members of the public as well. Members of the Conference Committee, as I think you're aware, our country faces an epidemic. The rate at which Americans die from the discharge of firearms is far, far higher than any country that we would want to compare ourselves to. 30,000 Americans per year, more than 1,200 of them children. And it's become so commonplace that we barely notice it unless it involves our own child, our parent, our family member, our friend. Now, at the same time, members, it's also true that millions of Americans, hundreds of thousands of Minnesotans, use firearms responsibly for hunting, for sport, for personal protection, as a hobby. And members, we can do more to keep guns out of the hands of people who have proven themselves to be dangerous, and at the same time uphold the rights of those many, many responsible, law-abiding gun owners. This is America. This is Minnesota. We can do both of those things. Minnesotans are calling on us to do both, and the two bills that you're going to hear about this afternoon that we're going to discuss do both. House File 8 is the source of the provision that's contained in the House's Conference Committee bill. This requires that the seller of a firearm verify that the person they're selling it to is actually eligible to possess it, that they're not a violent felon, a domestic abuser, somebody else not allowed to have it. It's important to note that most transfers of firearms occur through federally licensed dealers who must conduct a criminal background check, but transfers by other people don't currently require such a check. The bill simply requires that those other people, those non-dealers, get proof of a background check as well. I want to make sure we're very clear, Mr. Chair and members, that there are plenty of exceptions here. Long guns are excluded from the requirement here. Transfers among immediate family members, yes, may transfer to your child, a grandchild, a sibling, etc. Transfers when hunting or on the range, during competitions. I've heard from some parents concerned about their child participating in trap shooting, other sports. Should be no concern there, and many, many more exceptions. Members, criminal background checks on all sales is a proven policy. It's in use in more than 20 states with lower rates of gun death and other statistical benefits as well. It's also a policy with broad support. You have a letter in front of you from a broad coalition of our law enforcement leaders, our police chiefs and sheriffs, our county attorneys, and the Minnesota Police and Peace Officers Association. Support from health professionals, Governor Walz, Lieutenant Governor Flanagan, and according to polls, the vast majority of the public. And the bottom line, Mr. Chair and members, is that this is something that responsible gun owners, in many cases, already do. They would not give their guns to somebody else without knowing the person receiving it is actually eligible to receive it. It is time, members, to require that all firearm owners live up to that same standard. And that, Mr. Chair and members, I think accurately describes the bill.
Very well. Thank you, Representative Pinto. Mr. Rob Dorr from the Minnesota Gun Rights. Welcome to the committee, Mr. Dorr.
Thank you, Mr. Chair and Mr. Chair and Committee. I'm Rob Dorr. I'm the Political Director of the Minnesota Gun Owners Caucus. It is true this bill has had a pretty steep change since its initial introduction, and we appreciate a lot of those attempts to try to correct the issues in the bill, but unfortunately we still believe that the underlying premise of the bill is flawed. Our position has been perhaps oversimplified into just saying criminals don't follow the law, and you know, while that statement is true, that's a bit of an oversimplification of our position. I think our position is more accurately that when current laws are already being circumvented, the efficacy of new laws is suspect, and we need to evaluate why are the current laws not already working. We've seen time and time again in our nation's history when prohibition hasn't led to the elimination of the prohibited substance, only a shift from the suppliers. The market, the demand still remained the same. When you look at the Sentencing Guidelines Commission, there's some interesting information that came out just from this latest report that shows that only 39% of felons in possessions of firearms or firearms-related crimes get the minimum sentence, only 39%. We also have a 2019 report from the U.S. Department of Justice that shows that only 0.8% of firearms that are used by criminals are acquired at a gun show. And then on top of that, 56% from that same study were purchased off of the black market or stolen. And then beyond that, straw purchases remain one of the most common ways that criminals acquire firearms. And that same sentencing guideline report shows that 0 prosecutions or 0 convictions happened for somebody knowingly providing a firearm to a prohibited person. So that, again, there's a law right there that's not being effectively applied. And if there's changes that need to happen in that law, I believe there's merit around that conversation. But we're not fully exploring using the laws that we already have on the books. It's been said that 90% of people support this bill. That's a bit of an exaggeration. This bill goes well beyond just sales. And when you look at the polling questions, that's what's asked. 90% of people support criminal background checks on firearms sales, which is something that's mostly common practice right now, even in private sales. But what it doesn't talk about is the transfers, and therein lies the rub, is this applies to any time a firearm, and it's been narrowed down now to just pistols and sporting rifles, but anytime those change hands, now these apply. And I think that's a little bit inconsistent with the polling, and it's a bit of a non sequitur to use that as support. Nevertheless, this bill prevents you from being able to give your cousin, your godchild, your nephew, whole host of other family members, close personal friends, neighbors of 30 years, as Senator Tom Bach pointed out. It prevents you from being able to transfer a pistol or a sporting rifle to them. They can't use it for a whole hunting season. You can't even transfer that to them for defense of their home under this bill. That is unless they register as a gun owner with the state of Minnesota and they hang on to a piece of paper documenting their temporary transfer for 20 years. Failure to provide this piece of paper upon demand, and this isn't as subject to a warrant, just upon demand, is a gross misdemeanor. They'll charge you the gross misdemeanor for losing a piece of paper. And this is a statewide registry of gun owners. If you look at the funding request inside of the report, it has a appropriation to the BCA for a database of these permit to carry holders. Permit to purchase in this instance. So again, we're creating a registry of gun owners in efforts to attempt to stem criminal transfers of firearms. And another particularly egregious portion of this bill is that it greatly expands the authority that chief law enforcement officers have to deny a permit to purchase. Gives them and there's times in our recent history where chief law enforcement officers have abused this authority. They've been overzealous in their denials, and they've actually been taken to court, and this was the impetus for our 2003 and 2005 permit to carry laws, which turned Minnesota into a shall-issue state, because chief law enforcement officers were being overzealous in their denials and wrongfully denying somebody the exercise of a constitutional right because of their own personal feelings and their own personal bias. Now, I'm sure the vast majority of law enforcement officers, chief law enforcement officers are doing the right thing, but we have to protect those against, we have to protect the citizens against those who may not be as fair. The permit to carry law also spells out an appeals process for somebody who's wrongfully denied, and that appeals process holds them harmless. That process does not exist in this bill. There's literally nothing in this bill that stops a chief law enforcement officer from denying a permit to purchase to every single applicant who comes across and basically saying, sue me if you want it. Imagine having to sue somebody every time you wanted to purchase or transfer a firearm in order to get that permit to purchase or permit to carry. There's nothing, this is a barrier of entry to the exercise of a constitutional right, and this barrier is going to be felt even more so by those who have more frequent contacts with law enforcement and those in communities that believe they've been suffering from over-policing. And finally, we don't believe these bills work. A study by the University of California, Davis, evaluated 10 years of the state of California's universal background check laws. After 10 years, that state showed that it had zero impact on suicide rates or homicide rates that could be attributed to the background check law. An analysis of Washington State's universal background check law showed that 98% of firearm transfers were happening at retail establishments, which are already required to run these background checks. And Colorado results were very similar to that. A U.S. Department of Justice memo concluded that universal background checks are entirely unenforceable without a registry of firearms, unless they have somewhere to go back and verify the information that's on that background check report, and that would have to be a registry of firearms, that they're unenforceable. We disagree that we're in a crisis. Minnesota's violent crime rate has dropped 50% over the last 25 years, while gun ownership, permits to carry have skyrocketed over that same time frame. These laws do nothing to keep guns out of the hands of individuals who were actually worried about possessing firearms. And the big problem is they're much more likely to catch a good person in a paperwork mistake than they are to catch or obstruct a criminal who's already entering the illicit market to circumvent the background check process. So we challenge you guys, instead of pushing for failed, overzealous, overreaching, and divisive policies that have broad bipartisan opposition, please work together to focus on things that we can agree on will have a positive impact on public safety without infringing upon the rights of Minnesota's law-abiding gun owners. Thank you.
Very well. Thank you, Mr. Dorr. Dakota County Sheriff Tim Leslie, please come forward. Welcome to the committee, Sheriff Leslie.
Chair Mariani, thank you for having me. Chair Limmer, thank you again. I'm Tim Leslie, Dakota County Sheriff representing the Law Enforcement Coalition. Just a reminder, Minnesota Law Enforcement Coalition is made up of the Minnesota Police and Peace Officers Association, which is 10,000 members strong. That is our line, the men and women of law enforcement across the state. Minnesota Chiefs of Police Association, which represents over 300 police chiefs. Minnesota Sheriff's Association, Minnesota County Attorneys Association, which represents the 87 sheriffs and county attorneys, elected sheriffs and county attorneys across the state. Our coalition supports this legislation. And I want to thank the authors as well for including us along the way. This has been a journey. They've met our needs as we've moved this forward. We've had a lot of consternation and questions, and we've agreed to disagree on some things, but they've also included some of our concerns. One highlight, the additional discretion added for chiefs and sheriffs is especially important for us as chiefs and sheriffs, especially those issues where we encounter those who are dangerous to themselves or others, that we have the ability to hold up the process and get more information. I really think that's important. And with that, I'll stand for any questions if you should have any.
Thank you. Very, very well, Sheriff Leslie. Members, so this will move us to the third stage, if you will, of the bill presentations, and that's for question and answer from committee members.
Mr. Chair. Mr. Chair.
Representative Pinto.
I do want to just make a correction of something that, in my view, that Mr. Dorr said, just as a reference. And in general, we've, I think, had really good, accurate descriptions of things. I was concerned about the description that there would be a registration or some sort of registry as part of the bill to confirm the seller and the buyer both hold on to paperwork, keep it themselves. They would have to show if there was some criminal investigation, but there was no registration, no registry that's created here, and I want to be absolutely sure to clarify that. So thank you.
Very well, thank you. Members, question, Chair Lesch.
Thank you, Mr. Chair. Representative Pinto, to that point, is there anything in the bill that requires this registration to be an actual piece of paper?
And could if Chair Lesch could repeat the question, just make Mr. Word.
Does this have to be a piece of paper?
Oh.
Representative Pinto.
Thank you, Chair Limmer, Representative Lesch. No, it certainly does not. There's a requirement that the, well, I guess maybe the document that's issued by law enforcement would be a piece of paper, but then the requirement later on that the seller and the buyer would produce the record can be I recall it being in a digital form. It certainly can be. There's no requirement there be that piece of paper that's held on to. It's maybe worth just noting, because I did kind of skip over this so go quickly in the introduction, that the idea is that the buyer, we're talking about a non-licensed seller here, is that the buyer would obtain a permit to purchase from law enforcement, receive a background check. That permit would last for a year and an unlimited number of times that it could be used. And then the seller would need to see that permit to make sure that the buyer is in fact eligible to receive the firearm. And they both record information and keep a copy. And to Representative Lesch's question, it certainly could be an electronic copy to show that in fact made sure to be checking those boxes. The documents don't get sent into the government. There's no registration, nothing like that. They hold on to it unless there's a criminal investigation, in which case then it would be available to show. The seller could say, look, I made sure this person was in fact eligible to receive the firearm.
And, Mr. Chair?
Chair Lesch.
And for that, for that criminal investigation to commence, a law enforcement officer would need to have probable cause at some point to demand that you produce that, right?
Representative Pinto.
Thank you, Chair Mariani, Representative Lesch. There certainly would have to be, well, sort of the general standard for pursuing the investigation. So, yeah, in fact, the officer would have to be able to take that steps, and the same as any other investigation. That's exactly right.
Thank you.
Thank you.
Very well. Any further questions?
Mr. Chairman.
Chairman Limmer.
Mr. Chairman, I have a question for the testifier. Chief, when it comes to the question of holding on to a receipt, how long is the seller required to hold on to that receipt?
Mr. Chair, Senator Limmer,
Sheriff Leslie.
it appears to be 20 years. That's what's stated in the law. Same length as a dealer. I don't know what the author, why 20? He said same length as the dealer, so there is some comparison.
And, Mr. Chair, maybe I should direct this to Representative Pinto. Representative, I don't know about anyone else. I have a real hard time holding on to paper receipts, even for tax deduction purposes. And so if someone could not present a receipt, did I read that this could impose a criminal penalty of a gross misdemeanor on someone who cannot present a receipt? Is that correct?
Representative Pinto.
Thank you, Chair Mariani and Chair Limmer. So, Chair Limmer, I want to reference back, in answering that, I want to reference back to a comment made by Mr. Doerr about the fact that it's so difficult to prove this current statute we have, which says that if you are make a knowing transfer to someone that you know is ineligible to receive a firearm, there'd be a criminal penalty. It's very difficult to prove that. The setup under the bill is to really say that that a non-dealer seller is put in the same position as a dealer in terms of taking that responsibility when that firearm changes hands, that the person who receives it should actually be eligible to receive it. And so just as a dealer is required to be able to have those records for a number of years, in that case 20, the requirement is that a non-dealer seller would have the same requirement. I want to point out that it's certainly can be a digital copy, electronic copy, but yes, to circle back to answering your question, if in fact the seller does not keep that record, doesn't take that seriously in that role, and recognizing that's a very important responsibility that we do place on a firearm owner, that if it changes hands to somebody else, again, not immediate family members, all those exceptions, that yeah, you have to be able to show in future years that you took the steps to make sure the person was not a dangerous felon, was actually eligible to receive it. And so the answer to your question is yes, that there is a criminal penalty at that point, though there's plenty of flexibility to be able to meet that. You don't have to hold on to a paper record.
And Representative Pinto, the sheriff said something earlier about Cooperative expectation of federal license dealers. So is what you just said also applicable or currently being managed within that community of agents?
And Chair Mariani, my understanding is the expectations are at least as high, if not higher, but the length of time is, my understanding, is the same. It's a 20-year requirement on dealers that they have that requirement to keep those records, et cetera. And so in this case, the non-dealer sellers would have a similar length of time to keep those electronic records in whatever form to be able to produce them.
Well, Chairman Limmer.
Thank you, Mr. Chairman. Representative Pinto, I have a little concern about treating an individual citizen the same way you would treat a professional federal licensed dealer who sells guns for a living. There's all sorts of standards on anyone who's licensed as a professional in the state of Minnesota. Take, for example, I'm a realtor. I have a license to sell a property on behalf of a seller and a buyer anywhere in the state of Minnesota. But because of that license, I have certain requirements. Now, if I was just a plain old homeowner that wanted to sell my house to my neighbor, I don't need to be a licensed person, nor do I have to go through all the continued education, all of the information on on real estate law that I have to soak myself in on continued education requirements, nor would I have to hold on to the paperwork at all if it was just a private sale. Might be foolish not to hold on to your paperwork for that long of a time. But I certainly, as a buyer or a seller, I certainly wouldn't be penalized on a criminal charge for selling one transaction every 20 years. So how did you arrive at a gross misdemeanor charge? Is that something that's reflected in our sentencing guidelines? And I'm trying to understand the proportionality of how it affects other crimes.
Representative Pinto.
Thank you, Chair Mariani, and thank you, Chair Limmer, for the question. We've discussed a lot in our House discussions in our committee about setting criminal penalties in terms of a broader framework of what society thinks about certain conduct. And we need to remind ourselves that we're talking about a situation where, as far as anyone knows, this is a transaction, a sale that occurred without the required background check. It is important to all of us, and I know to responsible gun owners, that a firearm be transferred to people who actually are eligible to possess it, that they not be a dangerous felon, not be a domestic abuser, et cetera. And so the thought is that that is a serious enough infraction of our society's expectations that in fact it'd be at a gross misdemeanor level, not at the felony level, but also not at the misdemeanor level. And so that did seem like to be an appropriate criminal penalty for many of us.
Any further questions? Senator Latz? Oh, Senator Lang, I'm sorry.
Thank you, Mr. Chair, and thank you, Senator Latz. You know, over the last couple of minutes here, I've had a couple of questions. How many private to private person sales in Minnesota
Senator
do we have right
Lang, I apologize, but you're going to need to pull that mic a little bit closer to you. Our mics are notoriously short in this room. And,
I apologize for not being that way. How many private to private person sales right now in Minnesota are we every year?
Thank you, Chair Mariani. And Senator Lang, I'm not certain of the answer. I believe it's something like 15%. I'm sort of looking, I think there may be folks in the room who would have a sense of that. Though recall, one challenge here is that long gun sales are excluded. And so we'd also have to identify those that would be impacted by this, if that makes sense. I'm not sure offhand. There may be somebody else who can toss that out.
Actually, I could answer that. Of course, you don't ask a question without knowing the answer to it.
Oh, I should have just asked you.
But in all honesty, I have a few issues with how you define, and realistically on an overall basis, how Minnesota defines what a long gun is.
Right. You
use that terminology. I really have, anybody that knows guns, when you say long gun, it could mean a multitude of different things. There's, right now for FBI statistics, and I'm going off the top of my head because I didn't think I was going to go down this road, but I believe nationwide it's about 3% of all gun sales. There are some states that stand out a little bit higher than that, like California, Colorado being one at 7%. I believe Minnesota is under 2% right now for person-to-person sales. Do you know how many of those sales have been used in a crime?
Thank you, Chair Mariani. And I'll admit the 2% seems like that seems significantly lower than my understanding. I wonder if we may be talking about something different. Because I had remembered from an earlier hearing, even from the folks who are in opposition to this, estimating that something like 85% of sales are through dealers as opposed to 15%. So
right, and that's.
So I'm wondering.
I was recognizing the numbers that you were using and were quite different than what I was seeing from
so we, Chair Mariani, so we may be able to get some assistance with that, Senator Lang, from somebody. Right. But in any case, and then the number that are used in a crime, I believe was your question. And of course, that's so challenging because, of course, we do not track transactions, so it can be very difficult to know. I certainly know I work as a prosecutor. I'm not sure if I mentioned that before.
Sure,
and certainly find that's quite common.
The point I'm trying to make, and thank you, Mr. Chair. Sorry to step on you. The point I'm trying to make is oftentimes the straw man sales that are already illegal, that are person to person, are what I'm concerned with dealing with, of course, right? And I think Mr. Dorr mention a portion where he says 39%, I believe, is minimum sentences are not prosecuted. Just now, yesterday in the paper, in my local paper, there's a multiple-time felon that again was a felon in charge of a weapon that was dropped again. He's been in prison for 4 years and been on probation for 15 years and got caught. So I'm concerned that we're not enforcing the laws that are on the books right now, or you as a prosecutor would know that this is one of those things, and I've heard from several judges that this is one of those things that gets dropped all the time. This is one of the first things to go. Unfortunately, I think that's probably one of our biggest tools when it comes to enforcing the laws we have and enforcing it against these felons that probably are going to commit these crimes later on, regardless of how they got a weapon. There's also, you mentioned that the nation is calling for us to do this. People are calling upon us. I have never been inundated with the number of emails, phone calls, Facebook, of course. I believe it's about 10 or 11 to 1 against these in Minnesota, and that's not just my district, that's statewide. 90% of people support background checks. I'm concerned that that's not 100%. I'm wondering where the other 10% of those people are at. I support background checks. I support the fact that we need to make sure that the wrong people don't get guns in their hands. I don't think this is the way we go about doing it. Sorry, I'm pontificating a little bit here, but there's also, we talked about registry, and am I loud enough? Sorry. We talked about a registry. I was looking through the bill, and if you go to a section, it talks about monitoring, subsection 13 from 218 to 218, 1 to 218.21. If you remove paragraph D, this would fundamentally become a registry. That's all it would take. By my understanding of reading the bill and talking to counsel, that's all it would take to turn this bill into a registry bill.
Representative Pinto.
Well, regarding that last point, I mean, we could change all kinds of words and have all kinds of things happen. I mean,
Right.
it just doesn't do that. I guess I do want to note the idea that I guess it's important to recognize, back to an earlier point that you made, it is not, you talk about people receiving firearms and not enforcing laws, and I should note as a prosecutor, in my experience, certainly in my county, boy, those felon in possession cases, we absolutely prosecute them to the fullest, and there's a mandatory minimum, and that is something that we drive very hard at, and certainly I'm aware of my colleagues doing that. I do as well, but it's important to recognize that it is not currently illegal to sell a gun to somebody who you think probably is ineligible to have it, might be ineligible. It's just only if it's knowing. And as was referenced by Mr. Dorr, that is it's very, very difficult to prove that. I mean, it's almost impossible. So what this is requiring to say, hey, before that gun transfers hands, we want to make sure that the person who's receiving it is actually eligible to receive it. And I guess I would argue that in fact would. I mean, right now we have people who go to dealers who are ineligible to receive and are stopped by the background check system when they go to dealers. How much more often is it than they're doing on those private party transactions? The person selling it maybe wouldn't sell it to them if they knew that they were prohibited. And right now we need to have the process of saying that. And I guess the final point I'd just say is that say it's not the way to go, but recognizing that our chiefs, our sheriffs, our line police officers, and our county attorneys all disagree with that perspective. They view this as a way to keep our community safer.
And just one last thing, and then I'll sit back and be quiet. The fact that person purchasing the weapon from a private person, even if they don't know or have the reasonable expectation that person is not a prohibited person, they're breaking the law at that point. That would be the one. So they're breaking the law. They're a prohibited person. Shouldn't have the gun. What would at what point do we have some sort of responsibility upon that person? And then just one other thing you said when Senator Limmer was talking about the record and the gross misdemeanor charge. I believe it is if you don't file the record or keep it on hand. If you lose that, you get a misdemeanor charge. Would that prohibit you from getting a permit to purchase or permit to carry in the future, from having that misdemeanor charge in contact with law enforcement?
Representative Pinto.
Chair Mariani, Senator Lang, I don't think that it would, although we can certainly verify that with staff and maybe with the help. I want to make sure that I have a lot of floating through my head here, so I want to make sure that I'm getting that accurate. But I don't believe that it would.
Because, and
Senator Lang.
thank you, Chair. Per line 216.8 in that paragraph that follows it, paragraph B, the definition, the decision of a chief or police sheriff must be based on documental past contact with law enforcement. This would be past contact. It would probably be a criminal gross misdemeanor charge. Those sheriffs or police chiefs could, in all rights, deny them from permit to purchase in the future, correct?
Senator Pinto.
Thank you, Chair Mariani. And Senator Lang, I'm not going to substitute my judgment for the, I mean, we've got our chiefs and our sheriffs who I know we all have a lot of faith in. And so we'll have to see. I mean, I guess the language speaks for itself at that point. I do just want to note that the buyer, the person receiving the weapon right now, if they're not eligible to receive a weapon, then this wouldn't change that. But it's important to recognize this would change for the seller. Right now, the seller is not doing anything wrong in selling to that person. And what this does is make sure that the seller can have the confidence that the buyer is in fact eligible to receive it, and we can have the confidence that the buyer is actually eligible to receive it, and that transfer can in fact happen. The rest of us can have that confidence as well. Without any records being sent back to us, they hold on to the records themselves.
Senator Lang. Thank you. Senator Johnson.
Thank you, Mr. Chair, and thank you for bringing this bill forward. I think this is, I know you've done a lot of work, you've made a lot of changes in the bill to address a number of concerns, but I'd like to get back to your main premise of bringing this bill forward, and you said at the very beginning, this bill is an effort to keep guns out of the hands of criminals. Now, I'm concerned that criminals are getting guns, and we do have a number of bills, or a number of laws on the books that do address that. And I know that those, to varying degrees, get enforced, and we see some results from that. But I think this is the downside of viewing the state of Minnesota as one Minnesota. You know, in my neck of the woods, when you have a transfer, well, I'll give you a story. So I'm gone quite a bit from home during the winter time, and my wife does not necessarily enjoy that, so she feels a little unsafe. We don't have a pistol or a firearm like that. So my neighbor one day said, you know what, I've got one for you, why don't you just take this? Now under this circumstance, would we have to get a transfer permit for that?
Representative Pinto.
And Chair Mariani, if it were one of the kinds of firearms referenced here, which would include a pistol, then in that case, you would need to do that. There'd be no cost for the permit, et cetera, but you would need to get that permit from law enforcement, et cetera, and then have it be valid for a year, et cetera, but there would be that requirement in what you've described.
Mr. Chair,
Senator Johnson.
if I could just follow up with that. And that's the problem I'm having with these bills that are coming forward right now. We're treating folks as if they all have the potential of becoming criminals. You know, we've got these cases where, in my neck of the woods, this happens all the time, where folks are transferring guns. Why don't you take mine out to the woods? Why don't you do this? And no, that might be an AR-15, that might be, you know, a Monte Feltro that's going out. It may or may not be one of the ones that falls underneath that category. But we're treating everybody the same under this. And I think government becoming intrusive, being able to get involved in these private sales between, it's not always a criminal on the corner. It's not always somebody behind the 7-Eleven that's transferring a gun. It's neighbors, it's friends, it's those people that are hunting together, it's hunting parties. It's not always the same. So when we've got the Blackstone ratio where we want to, you know, we'll let go 10 criminals just to save, you know, one innocent from being caught. It seems like we're not following anything like that right now. What we're doing is presuming that everybody is going to create a crime or become a criminal. And I think the underlying premise of this bill is right. We want to keep guns out of the hands of criminals. But this is not the way of going about that. And there's other things. I actually have one question for the sheriff, if that's all right.
That's quite all right. Senator Johnson.
One follow-up, and we want to give sheriffs and law enforcement all the support that we can. And I think that's very critical. I do want to go back to the comment that you made earlier. If you could restate that of what it is about the bills that actually help law enforcement when they're going into those dangerous situations. And if there are any current laws on the books that we could tweak in order to do those, to help you out there. I'm thinking in particular the 72-hour hold law and why that isn't working.
Sheriff Leslie.
Chair Mariani. Yeah, and remember, I was referring to the added discretion that the sheriffs and chiefs would have. I think it's section B, a notice of disqualification or some kind of danger to self or others would be something that we would be able to use, but we would have to use and provide data on why we believe that to have occurred. I can't just say, you're a danger to yourself or others, therefore I deny. I'd have to have some foundation of documentation. Calls for service to that residence would be an example, where someone maybe was in crisis, threatening suicide, where we would press pause and say, let's get more information before we issue a permit to purchase and something like that. So that's what I was referring to in added discretion for chiefs and sheriffs.
Senator Johnson?
Chair. And my last point is just, I'm very concerned that the data that's required is not outlined clearly, and that there is such broad discretion that I worry that that could still be something that we could be abusing in the future here. So that's the only point I wanted to make there. Thank you, Mr. Chair.
Very well. Thank you, Senator Johnson. Representative Latz, or Senator Latz.
Thank you, Mr. Chair. It's been a long time since I was a
Yes.
representative. Yes.
You and I were in the chamber together.
That's right. Mr. Chairman, if I may take a moment to share a couple of thoughts on this bill. One of the questions that goes to the underlying purpose of the bill is its efficacy. How successful do we expect that this bill would be in reducing crime, particularly gun deaths? That's the primary focus of it. The data I have is that about 40% of the transactions, the transfers of firearms, this is a nationwide statistic, bypass the existing background check system, which is to say they don't go through the federally licensed firearms dealers. So that'd be a bit like going to the airport and trying to get on a plane, and 60% of the people would go through security, and the other 40% wouldn't. I don't know anyone in this day and age that would be comfortable getting on the plane under those circumstances. Yet that's what we do essentially with the transfer of firearms. And what backs up this concern is that the statistics, based on an analysis of FBI and the Center for Disease Control data, there are half as many deaths, women shot to death by intimate partners in the states that have universal background check laws. There are half as many law enforcement officers are killed with guns in those states. Half as many suicides by firearm, and half as many illegally trafficked guns. So basically, we'd be cutting deaths by suicide, law enforcement officers, and of women in domestic violence situations, we'd be cutting them in half. Statistically, the background, that's what this is telling us, if we pass a bill like this. Now, there actually was a state that gave us the perfect laboratory for analyzing this, and that was Missouri. Because for a long time, Missouri didn't have any background check laws. Then they passed a background check law, and then they unpassed it. They repealed it. And what happened is after they repealed their background checks, they found there were 25% more firearm homicides, and there was a 150% increase in the share of likely trafficked guns. So we've got the data that says that background checks work to prevent gun deaths and reduce gun trafficking. So I would actually say it'd be almost grossly negligent not to take a step like this if we can have this large of an impact on gun deaths by suicide or otherwise in Minnesota. I would like to emphasize that this bill, unlike previous proposals in previous years, this bill does not take every transaction and require it to go through an FFL. It just doesn't. It takes already existing statute in Minnesota, the permit to purchase system, and simply requires that all purchasers get that permit at no charge, and that all sellers view that permit. Now, when they get that permit, they're going to go through the background check conducted by the law enforcement officer or agency. It's going to be an annual basis, as Representative Pinto said. Some of the earlier proposals had it happening as frequently as every 30 days. We're having a permit expire every 30 days. And had limits on the number of firearms you could purchase. This proposal is not that restrictive. We've gone a long way toward addressing concerns that were raised by gun owners about this. So it'll be an annual permit only, no charge to get the permit, an unlimited number of firearms that could be purchased with this permit. And one of the things that we did in this bill to address the concerns about going a whole year without having information on people that are purchasing firearms who could have an intervening incident. Maybe they are convicted of domestic assault a month or 6 months after they get that permit to purchase. Without being able to update the background with new permit applications every month or every 6 months, we had to find a different way to get that information. So what we proposed was to beef up the system that reports incidents like this from the courts to the BCA. And that's where this BCA funding item comes in here. It's not a registry. It doesn't submit the names of all the transfers that are going on. In fact, no one would have any aggregate information about all the transfers that are going on. They'd all be private transactions, and they would remain private transactions. The information that is had is contained in the local law enforcement agency, and it's their permit to purchase. The agency would get information periodically about the permit to purchase holders. And if they are checking, they get information from the BCA that says, oh, the court has notified us that there's been a domestic assault conviction. Then they know that they should disqualify the permit to purchase. That's where it's basically an IT line in the budget to facilitate keeping the database up to date when there are incidents that would disqualify a person. The definition of long guns was mentioned as a concern, and in fact, there is no definition of long guns in this bill because it's not necessary to do so. The bill specifically applies to pistols and, I don't know what Mr. Dorr called these sporting rifles, but the bill says semi-automatic military-style assault weapons, pistols and SAM-saws. I know some people use those for sports, maybe they're calling them sporting rifles, but let's be clear on what they are. They're Kalashnikov AK-47s. They're Colt AR-15s. I mean, these are Uzis, semi-automatic pistol and carbine types. I mean, these are the firearms that are already in statute, already defined in statute 624.717, subdivision 7. I'm sorry, 624.712, subdivision 7. And pistols are also defined. So the bill only applies to pistols and SAM-saws. Everything else is not covered by this bill. So we use the catch-all term long guns because it's easier to say than itemizing hunting rifles of all the different types that there are and so on. But let's be clear on what's covered in the bill here. It's already been identified that the requirement to maintain the documentation is important in case there's a law enforcement investigation. And again, this is a way that we have avoided reporting all transactions to some central database. That was one of the main objections to previous bills, that it would create a registry. There's no possible way that a registry could be aggregated out of the information that is gathered in the context of this bill. And it's only in the context of a criminal investigation to try to determine the provenance of a firearm that was used, presumably, in a crime, that a seller would have to produce that documentation. That's the backup. You know, whichever direction they're going, if they've got the gun identified and they're trying to work their way back from, you know, who sold it last to the person who used it, or if they've got the serial number from the firearm when it first entered the stream of commerce from the manufacturer, which is through an FFL, and so they can trace the firearm that way. That's already done in existing law, by the way. But there's no way to aggregate this information. There was a reference then in the aggregation of information to the database. I think Senator Johnson may have mentioned this. Maybe it was Senator Lang. In existing statute, he said that if you eliminate, I'm sorry, in the new bill, if you eliminate paragraph D, then that's all you have to do is create a registry. But let's be clear, and this is lines 218.1 to 218.23 of the bill. The monitoring under subdivision 13 on line 218.9 specifically says, without expressly identifying an applicant. So the data that's being reported by law enforcement for purposes of this monitoring is the number of permits applied for, issued, suspended, revoked, number of permits currently valid, specific reasons for suspension or denial or revocation of the permits. And without expressly identifying an applicant, the number of denials or terminations based on the grounds listed earlier in the bill. And then there is expressly the provision that says nothing contained in this provision authorizes a registration, documentation, collection, or providing of serial numbers or data on firearms or on firearms owners. So even if you eliminated that, this is a belt and suspenders approach here. You could delete paragraph D, and there is still nothing in this proposed law that allows for the transmission of any individual identifying information. So again, you just cannot create a registry out of this. I wanted to address this issue about the enforcement of the felons in possession or ineligible persons in possession of firearms. Typically, is my understanding, I think the prosecutors in the room could verify this as well, is in the cases where those get dropped, typically either they're going to have some kind of difficulties in proving the case, or it's a less serious offense than the offense they're getting a conviction for. Typically, that's the way it would work out. So, I mean, plea bargaining is a fact of life. Our judicial system, our budget here would have to be 900% bigger if everyone went to trial in this state. So, yes, prosecutors making judgment calls as to what to drop of multiple charges. But I would say typically they're getting a conviction for the more serious offense if they're dropping an ineligible person charge. Senator Johnson also raised the question about his neighbor offering to give his wife a pistol. And yeah, his wife would have to apply for a permit to purchase, and I would assume, without knowing, that she would pass. But I don't know it, and the neighbor may or may not know it. I suppose it's theoretically possible that unless Senator Johnson did a background check on his wife before marrying her, that he may not even know if there's something way back in her history before they met that would have made her ineligible. My point is not in any way to suggest that there's any issues with Senator Johnson's wife. My point, however, is that there's a lot of information that we simply do not know about our friends and about our neighbors. And if you look at the existing list of what makes a person ineligible to possess a firearm, some of those convictions are lifetime bans on possession of firearms. So an incident 30 or 40 years ago, I mean, if you're charged with or convicted of armed robbery or other violent felonies, in some of those cases, you are banned for life from lawfully possessing a firearm. So I don't know I don't know what my neighbor's criminal background is, if anything. And they may not see fit to tell me when they move into the neighborhood no matter how good friends I become, that 30 years ago, you know, they were convicted of a domestic assault using a firearm or any other, some of these disqualifying events. And I don't know how you define a friend or a neighbor in statute. I mean, you can't really say, okay, we're going to say all friends are okay. Well, who's a friend? Is it someone that stood up in your wedding 20 years ago and you maybe exchange holiday cards once a year with them now or an occasional phone call? Or is it someone that you see every day that you hang out with and have a beer with on Friday nights because they're, you know, they're just people that you see on a regular basis? And when you start drawing the line, I mean, who's going to get upset when the statute says, no, you're not my friend? And how do you define neighbors? A neighbor in Minneapolis might be within one city block. A neighbor in parts of greater Minnesota, you might have to draw the line 5 or 10 miles out from the house to define neighbor. I mean, you just can't do it as a practical matter. So the definitional problems and the difficulties with just knowing who someone is, I think it's worth the safety benefits that this bill would bring us to require permits to purchase under the existing statutes. Mr. Chairman and members who are, oh, there's one other point I wanted to make. I'm sorry. The appeals process was raised. You know, if there's a denial of a permit. This is existing law. In fact, my recollection is that this appeals process was passed in 2003 when the shall issue permit to carry system was passed in Minnesota. It's my first year in the House. It's existing law that you can make an appeal of a denial.
Taken out.
What was taken out?
That provision.
No, that's a new subdivision. So under 624.7132 subdivision 13. There's also an appeals provision in 217.19 that would apply here. So we're dealing with existing laws, nothing new here. Mr. Chairman, I think the, I'm sorry, not statute 217.19, the bill, line 217.19, which is subdivision 8. And this is not a new language in the bill. It's existing language. Any person aggrieved by denial of a transferee permit may appeal the denial to the district court having jurisdiction over the county or municipality in which the denial occurred. So if there's a concern about that, well, that's the argument is with legislatures for the last 20 years that haven't changed it. I think this is a fairly minimal intrusion on people's freedom. It's a very simple process. It has the potential for saving a lot of lives. So I think it's a bill that ought to become law, Mr. Chairman. And thank you, committee, for the time.
Thank you, Senator Latz. We have Senator Moller, or Representative Moller. Oh, my goodness. Representative Moller.
Thank you, Mr. Chair. And a question for Representative Pinto. We've talked about transfers that wouldn't be required to undergo a background check here. And I just wanted to have you emphasize some of the language here of people who are excluded from the process. And I believe beginning on lines 225.10, that's the family member transfer. And then also talking about transfers made while hunting on 226.6. If you could just please explain those two provisions.
Representative Pinto.
Thank you, Mr. Chair, and thank you, Representative Moller, because this really has led to some confusion. I want to make sure we're absolutely clear. So there is a long list of exclusions. It actually starts at the bottom, page 224, and continues on for almost 2 pages. It certainly does include transfers between immediate family members, including spouses, parents, children, siblings, grandparents, grandchildren, et cetera. Yes, there's a transfer at shooting range and lawfully organized competitions, while hunting or trapping, certainly while in the presence of the transfer. Yes, of course, you can hand your firearm to somebody else and you're there, but a number of other exceptions as well that are all listed here. As I mentioned before, I'd heard some concern from parents thinking this would in some way limit their child's participation in sporting activities involving firearms. It should not do so, and there is quite a long list. I think Senator Latz did a terrific job of pointing out that, of course, that line of people that you know has to be drawn somewhere, to Senator Johnson's question, in terms of defining a friend or a neighbor. And at some point, you have to have that sense of, you don't know who that person may not know all those details, as Senator Latz referenced. But quite a few of these relationships and others are spelled out here as having no background check required at all. So thank you.
Representative Moller.
Thank you, Mr. Chair, and just a couple of other points that have been brought up. So currently, there are 3 crimes for ineligible persons possessing firearms. You've got the straw purchase, selling to an ineligible person, and felons in possession. And I think this has been brought up, but it's worth emphasizing, and again, as a prosecutor myself, the straw purchases and selling to an ineligible person, those 2 statutes require that the seller have knowledge that the person is ineligible. And that requirement that they have to have knowledge that they're ineligible is something very difficult, almost impossible. And so the background checks here really alleviate those concerns. I'll also note with the felon in possession cases, I had the sentencing guidelines statistics in front of me, and from 2013 to 2017, there were 1,708 offenders who were sentenced for felon in possession of a firearm. Those cases are taken very seriously. We prosecute those very aggressively. I've handled a number of those cases myself, and I think Senator Latz made a fair point of if that charge is in addition to other charges, sometimes that one may get dropped because there might be a murder charge or something more serious that then would get pled to. But we do see a number of those cases. Law enforcement takes those extremely seriously, and so do prosecutors. There was also a question about, are people even calling for this? And I'm kind of surprised by that. There are a number of parents, of mothers, there are a number of children who are doing this. I have kids. My kids are growing up in an environment of having to do active shooter drills. We've heard from people who are impacted by gun violence, whether it's a family member, a friend, a neighbor, survivors, and those who've lost loved ones are calling for this. And something that was said in one of the committee hearings by an HCMC doctor, which has stuck with me throughout as we've heard this bill a number of times, was just because we can't do everything doesn't mean we shouldn't do something. And so for all of those reasons, I am strongly in support of this bill. Thank you, Mr. Chair.
Thank you, Representative Moller. Chairman Limmer.
Thank you, Mr. Chair. I've been listening carefully to the discussion. Prior to the time we enacted concealed carry permits, up until that time, police chiefs were given the allowance to deny a permit to carry. I don't know if it was, I don't know how formal the reason was for that, but the language that I see on page 216 regarding the police chief having discretion to deny a transferee permit to buy a gun seems to be very reminiscent of that era. And prior to the legislature approving concealed carry permits, there were very few concealed carry permits issued by local police chiefs. What guarantee do I have that police chiefs aren't going to go back to their old ways and deny it for everyone because let's just err on the grounds of safety? And if no one gets a permit, well then theoretically there won't be any abuse by a gun. Does anyone have an answer to that?
Mr. Chair,
Chief
Senator Warner, I'll try. I'll admit there was fear back then in 2003 when permit to carry was enacted by law enforcement, the world was going to come to an end. The sun would not shine in the morning. That's proven false. You know, I deal with permits to carry every day in my office. I issue 4,000 annually. We deny 1%. So by and large, the law-abiding folk follow the rules. You're right. But in this circumstance, we're talking about some information that comes to law enforcement that would allow us to look deeper into what's going on there, which would prevent someone from getting a handgun or, as Senator Latz identified, those kind of rifles, which can initiate a lot of harm in a hurry. And it would give us an opportunity to take a deeper look, to prevent a suicide, to prevent some sort of horrific event from occurring in our communities. I think we have a responsibility to do that. And I think with the reporting mechanisms that's built into this law to the Commissioner of Public Safety, we will see exactly what we are doing and take a strong look if we are overstating or overextending our authorities. And I think what I've seen this session is you're not afraid to come after us and tell us where we've overextended our authority.
Chairman Limmer.
Mr. Chair, I've seen when things get into legislation and become law, try to repeal a law around this place. Pretty hard. And so if we did pass this, make it into law, I would be very concerned that it might take a very long time to ever repeal it if there was grounds for reason to do that. I just remember the days prior to the concealed carry that people that had very legitimate fear of their own, merchants that carried large amounts of cash to a bank window, things like that, they were flatly denied by local police chiefs. And we all know that police chiefs are appointed by political mayors. And oftentimes that political view is often reflected in the instruction a mayor or anyone else in political office would give to a subordinate. So I would think that the political issues should be resolved in the legislature and not by a political appointment. And I think that's a very important issue to remember in this area of this proposal. I'll leave it at that for now, Mr. Chair.
Thank you, Chairman Limmer.
Chair Mariani, if
Mr. Chair,
Yes, of course.
with the
Chair
denial
Leslie.
language that exists that Senator Latz brought forward, I know when I deny a permit to carry, for example, I have to have a very strong threshold to uphold that because it's going to go in front of a judge. And if I lose, I pay. The sheriff pays for that process. And so I have to keep a little fund aside for those I want to stand up on. And I confer with my county attorney's office, is this one we want to go with, or should I issue the permit? So there is a contemplative process, a deliberate process that I go through on whether I will challenge to the district court level a denial.
Mr. Chair.
and Mr. Chair, if I may add just briefly,
Representative Pinto.
I just want to note that not only are the chief executives of these agencies supportive of this, the chiefs and the sheriffs, but I just want to note that that our law enforcement officers are urging support of this criminal background check proposal and certainly including this discretion as well, and that they view this as something that will keep our community and our state safer. So not just those who are leading those agencies, but our line officers as well are strongly supportive of this. Thank you.
Sure.
Chairman Limmer.
The denial process that's referred to in this legislation is somewhat different than the denial process that's already in existing law. I would like to have counsel explain the difference.
Mr. Backus.
Mr. Chair and members, yes, the House position does add essentially the dangerousness denial for either the transferee permit or the transferor report. The process that the witness mentioned about the appeal and paying attorney's fees and things like that, that is not picked up in the House language relating to the transferee permit or the transfer report. So that would continue to exist for the permit to carry, but not in these instances. So the standard of proof, the attorney's fees, all that stuff is not included here for this.
Mr. Chairman.
Chairman Limmer.
One last issue. There's a lot of talk about whether this bill would create a gun owner registration. Quite honestly, I think it gets really close to that. It may not be held by a BCA file, but it is held, the transferee permits, the information on the permits are held by a government entity. And to me, and to very many people in this state, I think they think of that as a gun owner registry. And I think that's a major concern. Most of the time, most states try to avoid that. But I think this is a, for lack of a better term, a backdoor way of having a gun owner registry.
Well, actually,
Representative Pinto.
thank you, Mr. Chair. I actually think that Senator Latz may have a comment relating to that, and I'll be happy to defer to him. I saw his finger go up, and then happy to jump in either way.
Latz, you did speak to this earlier on this point.
Well, Mr. Chairman, that's existing law. That's existing law. We're just this bill would just bring more transactions into the fold of the existing law, but if that's already a registry, then that's existing law, and that was supported by those who passed the laws for transferee permits years ago. So it doesn't seem like we're creating anything new, if that's even a possibility. And it's not a list of who owns guns or what specific guns are owned or anything like that. It's an authorization that someone can purchase a gun if they wish to do so.
Chairman Limmer.
Mr. Chair, it would be a list of those interested in buying a gun someday, if they don't already own one already. And it would fill the gaps of gun ownership in the state. Another question that I have is on 216.8, which allows the chief of police or sheriff to refuse a grant to permit to a person who is in danger to self or others. I see that there's no real reference to how that's defined. What constitutes a danger to self or others? I would imagine if I talked to 3 different sheriffs or 3 different police chiefs, I would get 3 different opinions of what that is. It seems like an exceptionally vague language, and I think that would be a concern that would allow someone to be denied a transferee permit, perhaps in order to protect themselves.
Sheriff Leslie.
Mr. Chair, Senator Limmer. This is in language when we attend to calls for service where someone's in crisis. That's the same style language, danger to self or others, that allows the police officer, the deputy, to bring someone to put a 72-hour hold, and bring someone to a facility, a medical facility for evaluation. If after they're evaluated, they're free to leave sometimes they're held. That's a decision made by the medical community, not by law enforcement. The decision to transport someone is by law enforcement. So that's that same language. Yes, there is discretion within that. I admit that. But at some point, we're going to have to rely on law enforcement to use their best judgment on that.
Chairman Lesch.
Thank you, Mr. Chair. Sheriff Leslie, that language referenced by Senator Limmer requires that the notice of disqualification describe the law enforcement contacts relied upon in the denial, and that is included in the same paragraph that describes the shall refuse predicated on a person who is a danger to self or others. Is that those law enforcement contacts presumptively giving you the information about the applicant's danger to self or others?
Mr. Chair, Representative Lesch, that's correct. That would be based on calls for service For me, as sheriff, I do all the permits to carry for the entire county, but I just do permits to purchase for those who reside in the area that the sheriff patrols. So that's what I would see, is that data. Each police chief would then be able to look inside their calls for service in their community and determine if there was crisis calls there. If the person had a situation where they were acting out, maybe had to be transported to detox, or you know, some kind of thing that would indicate threatening suicide. We're seeing a lot of that right now. I don't know what it is, but that's kind of the nature of the environment we're operating in right now. Is there's a lot of crisis going on in the communities that we serve.
Mr. Chair.
Lesch.
Sheriff Leslie, how are these findings kept? How do you retain these? I mean, do you make these findings when you send the notice of disqualification? They're included on there? Or are there any other way that you keep the findings of a person being a danger to self or others?
Sheriff Leslie.
Representative, Mr. Chair, members, we don't keep a database, but we keep calls for service that we respond to, and that's kept for a long period of time that we get to look at. It's a data retention schedule that it's on. It gets destroyed after a certain period of time, so that's what we would access.
Well, Mr. Chair, you know, I heard Senator Limmer's concerns that this is a rollback to pre-2003 law, and I was here in 2003. I remember the whole debate. In fact, I carried the reviser's bill that year where we had to determine whether it was and or for notice of no guns on this premises, which was a big hoo-ah at the time. But I still see this language as squarely shall issue with certain exceptions, such as the exceptions contained in 216.8. And there are some folks that don't think that worked out well. It's in the imposition of a statewide standard that may work perfectly well in Lake County, but not great in Ramsey County. Whether there were abuses of discretion by metro area law enforcement chiefs or sheriffs notwithstanding, I think we tacked well in favor of wide distribution in cases where maybe we shouldn't have. And this, I think, just gives extra added protection for those chiefs who don't want to give permits to nutcases that everyone in this room would agree is a nutcase. So I guess I have a little bit of difference of opinion with Senator Limmer than that. I understand that prior to the 2003 changes, there was no need for findings. It was just simple discretion. You get one, you don't. And folks deferred in favor of you don't a lot more than was some people's preference. And hence we ended up with the 2003 shall issue language. That's all, Mr. Chair.
Representative Zerwas.
Well, thank you, Mr. Chair. And I think it's interesting, Representative Lesch talked about the discretion for being able to deny a transfer permit for all the, did you say nutbags? Nutcases that we all know of. But that's not what the sheriff just said. The sheriff, in giving an example of when a permit to transfer could not be issued under this language, said if the person had been to detox. That was an example he used about 90 seconds ago. And so my question to the sheriff is, under what state or federal statute would that be an exclusion to possess a firearm? And is that how you would, and other sheriffs would, interpret this broadness in your language here in this proposed bill, that if a police department could demonstrate that a 21-year-old or heck, a 35-year-old at a Vikings game had previously been transported to detox, that under your interpretation of what you just said moments ago, under this broad language, would be a prohibition for a permit to transfer.
Sheriff Leslie.
Mr. Chair, members, that was a poor example. Sorry. So I'm talking about danger to self or others. Sometimes when someone is severely intoxicated, they'd be considered a danger to themselves if you left them there. So that was a poor example for a reason you would disqualify someone for a permit. What I'm saying is I think law enforcement in general deals with people who are a danger to themselves or others because that's the frame of reference is used to take someone to detox.
Mr. Chair.
Representative Zerwas.
Well, thank you, Mr. Chair. And I think that poor example illustrates the problem with the language in this bill. Is you now are asking 87 sheriffs and hundreds of police chiefs to come up with their own examples of why we're going to deny a permit. And some sheriffs and some chiefs, they might come up with poor examples of why to donate, why to prohibit the transfer of a firearm. And guess what? In this language, unlike in the permit to carry language, there isn't the same appeal protection within this language. And so, if you're unlucky enough to live in a city or a county where the sheriff decides to have a poor example of a reason to deny you your Second Amendment right, you have to go to this old language of appealing it, not the language under the permit to carry. Just another example on the multitudes of examples raised here today and other hearings of why this bill isn't appropriate and why this bill isn't ready. The idea that across 87 counties in the state of Minnesota and hundreds of municipalities, you would have different reasons for maybe, potentially, kinda, or maybe just a poor reason for denying someone their Second Amendment rights. This bill is not well thought out, and it's not ready.
Very well. Members, I have no other, anyone signed up for questions, comments? So with that, Representative Pinto.
Just a couple closing remarks, Mr. Chair and members. I do want to note the section regarding monitoring, and I kind of missed this, I think it was Senator Lang who first brought it up, and I missed it at the time, and I'm quite understanding. That particular section was offered by the Republican minority in the House as an amendment, and folks who have concerns, I think, with the other parts of the bill, but wanted to make sure that in fact this was being tracked. And so certainly if members from the Senate have concerns about that particular report for some reason, that was actually added by the Republican minority, and we could certainly discuss that, and certainly if there's aspects of making sure that the appeal process is lined up in each of these areas, happy to work with you on that more. But I want to again emphasize that this is not breaking new ground. This is in use in many other states. We are being called for this by law enforcement, by our chiefs, by our sheriffs, by our police officers, by our county attorneys. And essentially what we're saying is simply we're all fine with sellers who happen to be dealers requiring background checks. This is simply saying that those sellers who do not happen to be dealers should also make sure that there is a background check, and it sets up an easy and no-cost system, no cost to get the permit. A system that is very focused on a limited number and type of firearms, narrowly tailored. But given the situation, it seems to many of us and to, again, many, many Minnesotans that we would have that same requirement on those sellers who happen not to be dealers as on those sellers who are dealers to make sure that when the firearm changes hands, it changes hands into someone who is actually eligible to receive it and is not prohibited from receiving it. I appreciate members and members of the public, the discussion we've had, and Sheriff Leslie as well, and certainly would urge your support for this being incorporated in our final work product. Thank you, Mr. Chair.
Thank you, Representative Pinto, and I too want to thank the committee members from both the Senate and the House on both sides of the aisle for the deliberate and thoughtful engagement of today's conversation. I want to thank Sheriff Leslie for his testimony. I think, sir, you shared the difficulty and conscientiousness of your thought processes in regards to this issue, and clearly you and your colleagues take our existing laws seriously. Mr. Dorr, I want to apologize to you because I identified your group as the Minnesota Gun Rights, and that's absolutely wrong. It's the Minnesota Gun Owners Caucus. And so my apologies to you, and thank you for your testimony, sir, as well. With that, members, we're going to move on to House File 9, Representative Richardson. And Representative Richardson, what we're doing here is consistent with the practice of the last week when the House has had the gavel, is to lay before the conference committee provisions that that are not in the Senate bill as a way to establish a base knowledge of the House provisions. So what we're looking for is a very concise technical explanation of the bill, of the provision. We then will take testimony not to exceed 3 to 5 minutes from someone in opposition to the provision, and then someone in support of the provision. So we will be hearing after you from Mr. Brian Ghosh, and I apologize if I mispronounce your last name, of the National Rifle Association, and then from Chief Jeff Potts of the Bloomington Police Department. We will then follow those brief statements with questions and answers and comments from the committee members. But before we get started, I just want to check in with you, Mr. Chairman. I know that the Senate has a floor session at some point, and we'll look for your guidance in terms of how you want to proceed.
Mr. Chair,
given that apparent fact.
I've been getting kind of mixed signals from the Senate chamber of whether we're meeting or whether we're not meeting. I would say right now nothing is confirmed. I know that leadership was meeting with people in the governor's office, and whether that's going on simultaneously or not with the session, I don't know. But we'll have people ask that question, and I would suggest we just keep moving forward until we're roped back into the Senate chamber.
Very well, and hopefully, Senator, those conversations will contribute to some good fruit that will allow us to move forward in this conference committee in the coming day or so. So with that, we will continue, members. Representative Richardson, House File 9, Firearms, law enforcement, and family members enabled to petition a court to prohibit people from possessing firearms if they pose a significant danger to themselves or others by possessing a firearm, commonly known as the Extreme Risk Protection Order. Representative Richardson.
Thank you, Mr. Chair. So House File 9 establishes a process to obtain an extreme risk protection order, which would allow for the temporary removal of guns from people who have been found by a judge to present a risk of harm to themselves or to others. Extreme risk laws create a mechanism for law enforcement to temporarily prevent access to guns by individuals at an elevated risk of endangering themselves or others. And just a point of clarification, the petitions can only be done by law enforcement or by a city or county attorney, not by a family member. The laws are modeled after domestic violence protection orders. The process involves a court hearing and due process protections. There are 2 types of orders. The default would be that law enforcement or a city or county attorney would be able to petition a civil court for an order based on evidence that they present at a hearing before a judge, and the respondent would have the opportunity to be present, and they would be able to be heard and present evidence. In cases of imminent risk of harm, petitioners can present evidence, being the law enforcement or county attorneys, to seek what we would call an emergency order. And with an emergency order, that would allow for a temporary transfer of firearms for for a limited amount of times, up to 14 days, and that would require a court hearing within that 14-day period. Extreme risk laws are not new. In fact, in the United States, they have a 20-year history. The very first extreme risk law was passed in Connecticut in 1999 after a Connecticut lottery worker killed 4 of his co-workers than himself. And this was an individual that was known to be troubled. And prior to the tragedy, there had been individuals who had reached out to law enforcement because there were signs related to this. One of the things that we see oftentimes with states that have adopted these extreme risk laws, they often follow a tragedy. That's what happened in Connecticut. The same thing in Indiana, which was the second state to pass an extreme risk law. And in that situation, police had actually seized the guns of that individual who they knew to be a risk, but they had no law on their side in order to keep those guns within their possession. After they were forced to return those guns, that individual killed not only his mother, but a police officer, and 4 other individuals were wounded as a result of that as well. We've heard about many of the tragedies that have resulted in states passing red flag laws. Most recently, the Parkland shooting in Florida. Florida has now also passed an extreme risk protection law on the basis of that tragedy as well. We talk a lot about, with extreme risk protection orders, we've talked a lot about the issue of mass shootings, and that was at the heart of Connecticut's law, Florida's law, and many of the other laws that have passed. But it's also important to understand that what we've learned over the years, over 20 years of having these laws within our state, is within the U.S., is that extreme risk protection orders can also be a strategy in suicide prevention. And the 10 years following enactment, Indiana's law, for example, was associated with an estimated 7.5% fewer firearm suicides. Here in Minnesota, we have a definite public health crisis when it comes to gun deaths and suicides. In 2017, there are 465 gun deaths in Minnesota. 78% of those were deaths by suicide. Suicide has a significant emotional cost on our families and the overall community as well. We need to think not only about why people are taking their own lives, but also how they take their lives if we are to be effective in our suicide prevention aims. Too many families and communities have been shattered, and it should not take an unspeakable tragedy for our state to proactively address these threats. Keeping guns out of the hands of people who present a risk to themselves or others is not a partisan issue, as been demonstrated by the fact that extreme risk laws have been passed in both Republican and Democratic states. While we know that no policy is perfect, extreme risk laws can be a part of a strategy to fill gaps in our systems and can be an important part of community-based approaches to reducing homicides and suicides. Thank you, Mr. Chair.
Thank you, Representative Richardson. With that, then, we will hear from Mr. Brian Ghosh of the National Rifle Association. Welcome to the committee, sir.
Well, thank you, Representative Richardson. Thank you, chairs, members of the Public Safety Judiciary Conference Committee. My name is Brian Ghosh. I'm a lawyer and registered lobbyist for the National Rifle Association of America. Like many of these bills that have been introduced in different states, it has a laudable goal that falls apart when you look into the actual mechanics and the resultant erosion of civil liberties while failing to address mental health issues. I've got serious concerns with the procedures and the low standards required to get an order of protection. As Representative Richardson said, there are 2 types of extreme risk protection orders in this bill. The first is one in which a petitioner makes the petition, files it, asks the court to issue a hearing order within 14 days. However, the respondent can be given very little notice, as little as 12 hours notice prior to the hearing. I think that's a very short window to have the opportunity to lawyer up, so to speak, and prepare their side of the case. At the hearing, the petitioner only needs to show a preponderance of the evidence that the respondent is a danger to themselves or others. Also a low standard considering they're going to possibly lose their constitutional right, their Second Amendment right to keep and bear arms, and also lose property through a seizure process. If the court determines that the preponderance standard has been met and issues an order for transfer, the respondent can only transfer those firearms to a law enforcement agency or to an FFL. They cannot transfer that firearm to a friend or relative, as is allowed in other places under Minnesota law. The protection order can remain in effect for up to 2 years and be renewed in perpetuity, so it could last the whole life of the respondent. The other type of extreme risk protection order mentioned by Representative Richardson is the one that has the allegation of imminent threat. So this is the emergency one. And in this one, it's done ex parte, and I know there's a lot of lawyers in this conference committee, and you know what that means. It's no opportunity to be heard by the respondent, no opportunity to appear, not even submit a letter on their defense of what their side of the argument would be. Also, this bill essentially eliminates or suspends the court rules of 3.01 and 3.02 regarding ex parte hearings and orders in Minnesota courts. The ex parte order can be approved based on reasonable grounds. Reasonable grounds is different than preponderance of the evidence. It's also a very low standard. It's below probable cause. And when you consider Section 3 of the bill, Subdivision 2, Subpart C, this seems to be a catch-all provision for the type of evidence the court can consider, which could include arguably hearsay and uncorroborated evidence. Once the transfer order is issued by the judge, the respondent, again, only gets 24 hours from the issuance of the order, not when the service occurs on the respondent. So also a very short time frame to surrender those firearms. And again, it's only to an FFL or LEA, not to a friend or relative. And also within this section, there's a third standard of evidence applied. It's the probable cause in order to get the warrant to seize those firearms. So this bill, as written, only removes firearms from the respondent and no other dangerous weapons or objects. There was a story somewhat recently about a husband killing his wife with a corn rake. This bill would allow corn rakes, knives, explosives, and other dangerous objects to remain with the respondent, who ostensibly is a dangerous individual. Along those lines, there's nothing in this bill about the respondent getting mental health treatment or even evaluated by a mental health professional. There's no requirement that the respondent begin a regimen of psychotropic medications to make them less dangerous. The mechanics of this bill may also lead to the seizure of firearms of innocent owners with no clear path for the return of the same or the right to be compensated in the event the firearms are damaged or lost in the transfer. Finally, as written, this language is inconsistent with the domestic abuse statutes found at Chapter 518B that have different standards of notice, the hearing requirements before property can be taken, particularly the firearms. For the foregoing reasons and others, we would oppose House File 9 and ask you for a no vote. Thank you.
Thank you, Mr. Gosch. Thank you for your concise testimony. Jeff Potts, Bloomington Chief of Police. Welcome, Chief Potts.
Thank you, Mr. Chair and members. My name is Jeff Potts. I'm the police chief in Bloomington, but also serving as the current president of the Minnesota Chiefs Association. I am here on behalf of the Minnesota Chiefs Association and the Minnesota County Attorneys Association. We encourage the Minnesota legislature to pass House File 9, legislation that provides police and prosecutors with a powerful tool to prevent gun violence. House File 9 allows law enforcement to request a judge to issue an extreme risk order, a civil court order, to temporarily prohibit a person in crisis from possessing or purchasing firearms. Extreme risk protection orders call for both a court hearing and a clearly defined due process protections. If a court issues an order against an individual who is deemed to be a danger to themselves or other, respondents are able to petition for an early termination of the order. While we understand that the extreme risk protection orders are not a panacea to solve all gun violence, we think such legislation is important to help in specific situations and prevent suicides. There are 13 states with extreme risk orders that have seen positive results, and are saving lives. Our organizations are committed to supporting these important changes, and we appreciate your work with us thus far. Thank you, Mr. Chair.
Thank you, Chief Potts. So members, questions, comments? Representative Pinto.
Thank you, Mr. Chair. I wonder if Representative Richardson can talk about, I know that she's done some research on this, on how this has been working in other states. And I know there's been some concern expressed about kind of precisely how would this work. So if she could share that, or if Chief may know as well.
Representative Richardson.
Thank you, Mr. Chair. We've had the opportunity to do some research to see how this has been working in other states. I spent some time talking with individuals who have implemented this in San Diego. They've been doing this now for a little over a year in San Diego. And at the time when I spoke to them, they had processed 120 orders to date when I talked with them. And one of the things that they had identified that had been sort of more of a surprise to them in terms of how this process looked. When they receive an order, they've really have taken on the process of really sort of de-escalating things. And so we've heard these concerns about people being woken up at 3 o'clock in the morning with law enforcement knocking at their door, like demanding that they turn over their firearms. And what they've really found is by engaging people in the community, either through a traffic stop, when someone's taking their garbage out, they have had conversations with individuals, and in 119 of the cases out of 120, individuals had worked with law enforcement and turned their guns over. And what they also identified that was also very surprising to them, a number of the orders that they had issued were people who were at a risk of harm to themselves. And they talked about the number of individuals who they had come back to them to say thank you, because it was really something that that interaction was something that had really saved a life in a moment of crisis. And so understanding that the way that they've really implemented this, it's not sort of the SWAT-like level of response on someone's house, but they've really used de-escalation techniques and have really defined this as sort of a cooling off period for the parties if we're talking about a domestic situation, or if someone is in crisis, to really approach them from a way of trying to help to de-escalate a situation.
Representative Pinto.
Thank you, Mr. Chair. And maybe Chief Potts can just build on that a bit about how you would see this working specifically in your community, or if you can think of if there's a situation where this would have been helpful, but sort of how this would actually work on the ground with your force.
Chief Potts.
Sure, Mr. Chair, Representative Pinto, it really goes a lot in line with what Representative Richardson just described, that once the order is issued, I would foresee that we would be, the order would require the person to surrender the firearms within 24 hours. So law enforcement would be made available. Obviously, while this process is going on, they would know the time frame for which the firearms would be submitted, and law enforcement would be working with the individual to make that process go as smoothly as possible. As Representative Richardson said, if it isn't going as cooperatively as we would hope, there's certainly techniques and tactics such as just de-escalation. Officers are dealing with situations, unfortunately, where people aren't cooperative all the time, and have become very good at those tactics. And so where we look at other states who have done this, we've seen that to be the case, is that the surrenders go smoothly. Law enforcement is ready, if they don't, to deal with them very smartly, but also law enforcement, I think, would recognize that leaving the firearms in the person's home when the court has seen the situation to be unsafe, that it's our obligation to work to try and get those firearms in a place where they are separated from the person safely. And from an operational standpoint, I think Representative Pinto that because we haven't done it before, we would look to other states to see what are some best practices.
Representative Pinto.
Thank you, Mr. Chair. And I want to make sure to emphasize to colleagues and members of the public, too, this is something that would be, this only law enforcement or county attorneys could bring the petition. It wouldn't be private individuals at all. And so it's really something that should be a tool to be available when there are situations as there are. And I know that in Florida, this was recently adopted, Republican governor, Republican legislature, adopted in Florida after the Parkland shooting, and the young man there had exhibited signs that may well have, law enforcement would have wanted to be able to act on, and this was passed afterwards to give that tool so that if it's necessary, it's a tool in the toolbox to use. And I've heard a lot of concern expressed by folks about some sort of, about scenarios involving this that I think don't acknowledge the reality of how law enforcement works and engaging with the community, de-escalation, et cetera, to make sure that when you've got a situation that presents some danger, that it can be, that can be dealt with in a way that reduces that danger, and this is certainly part of the components of it. And I guess one final question for Representative Richardson is just, again, to deal with misconceptions about due process contained in here, because I've heard some concerns that somehow there's not due process. As I view it, there's plenty and quite a lot in this, but if she could just share that, Mr. Chair, as a final question.
Representative Richardson.
Thank you, Mr. Chair. So when we're talking about the default orders, what that really means is that law enforcement would have the opportunity to present its evidence. The respondent would also have the opportunity to present their evidence as well, and the judge ultimately would be in the position of making the decision of whether to issue an order. Excuse me. An order could be issued for up to 2 years within that process, and an individual would have the opportunity to petition for an early release from an order as well. If we're talking about someone who law enforcement has determined poses an imminent risk, that would be the emergency order that would be issued. That would require that a hearing be, a full hearing be convened within that 14-day period.
Thank you, Mr. Chair. Thank you, Representative Pinto.
Chair.
Chairman Limmer.
Thank you, Mr. Chair. Chief Potts, how would a police chief determine whether or not to inform a court of some type of imminent danger? What would they rely on?
Chief Potts.
Mr. Chair and Chair Limmer, the scenario that I can envision where this to become law would be a family member may notify us of a family member who is in crisis and also indicate that that person has access to firearms. It may also come while we have a police interaction with someone and we determine or observe some characteristics that lead us to believe that that person is in some serious crisis. And so it could come to us in multiple different ways, family or friends, but also in law enforcement dealing with a person in our community who we observe to be dealing in crisis.
Chairman Limmer.
Sure, I am a little concerned about the ex parte perspective on this bill. I understand there could be timing involved that might require that. But nevertheless, I'm always concerned about the government taking any property away from a citizen. And without a clear definition of when does government intercede, when does government petition the court, and what information it relies on is of question. We're all concerned about the safety of families. When we're dealing with the safety of families and trying to balance it with the Second Amendment, that's the struggle that we all have right now. Nevertheless, I am concerned about the ex parte notion of this and concerned that there doesn't appear to be a clear standard of when to initiate the request to the courts. Is it based on someone yelling at kids because they're cutting across the yard in bicycles and the guy happens to say, "You come back here, I'm going to kill you brats"? Is that enough? Or certainly, if there was abuse in the family, of course there would be reason to interact. So where do we draw the line? And how clearly is it defined for a police officer or a county attorney to initiate action to go all the way to the court to seek an ex parte order? Yeah, have you thought of that at all, Representative Richardson?
Representative Richardson.
Thank you, Mr. Chair, and thank you, Senator Limmer, as well. And as you're thinking about how this sort of looks in practice in terms of when law enforcement would decide that they feel that there's enough evidence to go to the court, I think, you know, to Chief Potts's point, it's really going to depend on the circumstances. And I think looking at the situations of, you know, some of the states that have implemented red flag laws, it gives us an idea of what types of cases of where they're saying that there's enough evidence to go before a court. If you look at Connecticut, for example, again, they've had a red flag law for almost 20 years now. It'll be 20 years, I think, in June. And they've done some research, and on that research, they've looked at over 700 orders. And so that information is available to be able to say what was the situation, what was the investigation, what did they find, and did they make a determination to go to a court. They also have information on sort of people called, but then they made a decision not to pursue that. So there definitely is data out there in terms of when is law enforcement making those decisions, and it really is going to rely on their expertise in terms of seeing what's available in investigations. In some of the cases, they were looking at threats that appeared on social media that they found to be credible. In the majority of cases, there were individuals who were at risk of harming themselves. And to just give you an example of those 700 orders that Connecticut has processed, in 73% of those cases, there was enough evidence that the individuals were not left at the scene. So the people who were the subject of those orders, in 61% of the cases, they were transported to the emergency room for a mental health evaluation to determine whether a psychiatric hold was warranted. And in 32% of those cases, there was some sort of crime at the root that was further investigated. And so the fact that we have other states that have done this, I think we've got an opportunity to learn from the way that they've implemented those.
Mr. Chair.
Chairman Limmer.
Mr. Chair, Representative Richardson, I'd like to bring us back to the bill. In the bill, you have reference that an individual who is, if the courts react and issue an ex parte order, the individual or the subject could be given up to 24 hours to respond. I'm a little concerned about the vagueness of up to. That means maybe 1 hour notice, the way the bill is written. That isn't going to give anyone much notice to give up something of some weapon in their home. Might be an unhealthy reaction if it were that. Why did you write it that way?
Representative Richardson.
Thank you, Mr. Chair. Thank you, Senator Limmer, for the question. And so when we're talking about someone who has been found to be at imminent risk of either harming themselves or harming someone else, we know that that time is definitely going to be of the essence. And one of the issues that Chief Potts alluded to as well is if it's a situation where law enforcement is responding to a call, they may already be on site. And so in those types of situations, we want to make sure that they're going to be able to appropriately secure those scenes and to make sure that we're not delaying the removal in a situation of where we know that there's heightened risk.
Mr. Chair.
Chairman Limmer.
Mr. Chair, I'm trying to imagine how this would work. You have an individual who's reported to be either unstable or perhaps tendencies of violence. The police have been informed. The police weigh that information. They bring it to the courts. The courts makes an ex parte order. They really haven't, the subject doesn't really know what's going on because it's an ex parte order. And all of a sudden he gets a signal or a phone call. I don't know if it's a phone call or if it's someone delivers a message to him that says, you have to give up the guns in your house. Now keep in mind this person might be unstable. He might feel betrayed by his own family members because now somebody knows something outside of the family circle and it's something official. And I'm just wondering how that individual's going to react. Quite honestly, I think they have three choices. They can give up their guns, they might hide their guns, or they might load their guns. And I really feel sorry for the next person that's going to come up to that door and ring the doorbell. And I'm just wondering I have a great concern about the police officers that are going to come up to that door. And if it's successful that these weapons are taken out, what do we do about that subject? What do we do about that? Does he remain in the house? I don't think the bill says anything about that. So the guy is left in his house with his trembling wife, and we haven't done anything about the baseball bats, the knives, the crowbars, or anything else in the house that can do damage, and he's one ticked off guy. Where in this bill does that take care of those issues?
Representative Richardson and Chief Potts, I think you also spoke earlier about observing best practices across the nation in this regard. So I think there's a lot that could be offered sure. Here to the chairman's questions. But Representative Richardson, I'll start with you.
Thank you, Mr. Chair, and thank you, Senator Limmer, for the questions. To your last point about leaving the person at the scene, there's nothing in this bill that would prevent law enforcement from undergoing any current practice that is available to them at law. So if the individual needs to be transported to an emergency room for an evaluation, that can occur. If there is a underlying crime at the root of this, there's nothing that prevents them from being arrested. And again, looking at Connecticut, which has processed more of these orders than I think any other state, over 700 of them, in 73% of the cases, the individuals were not left at the scene that were the subject of those orders. Again, the vast majority of them were transported, to emergency rooms. And when you think about the actual the service of an order, what that could look like. Again, I think with San Diego, what they found was that it was less effective, again, to go knocking at someone's door at 3 o'clock in the morning and saying, hey, you are the subject of this order. And so they really focused on de-escalating the situation and coming into contact with the subject of orders in ways that didn't necessarily mean that they were even at their house, so that they could have a conversation. And again, they've been doing this for a little over a year, and in 119 out of 120 cases, they negotiated with the subjects of those those orders, and they were able to have them peacefully transfer the guns. They only required what we would consider sort of a SWAT-like level response in one of those cases in a little over a year period. So law enforcement would have all of the tools that they currently have at their disposal when they're interacting with people who are either exhibiting a crisis that involves potentially harming themselves or others.
Chairman.
Mr. Chair, if I may add just a little bit to that,
that.
Mr. Chair and Chair Limmer, in kind of a practical sense, what we would see happening, and at least in the city where I am, where I work, is the person in this case in an emergency order, as Representative Richardson, could likely be transported to the hospital on what is called a transport hold. Now, law enforcement doesn't have the authority to ensure that that person's there for 72 hours. It was mentioned by Sheriff Leslie that we have the authority to sign the hold for transport, but that's as far as our authority goes. I would foresee that this type of a situation may be used in a case like that. The decision to hold the person longer really resides with the physician, and we would have available resources from our public health department. We're in the process of rolling out an embedded social worker program that can help with situations just like this. And our goal in this is to try to ensure that the person gets connected to the help that they need to stay out of crisis. And I wouldn't foresee, utilizing this tool unless we thought that there was an imminent threat that we need to separate this person from the firearms. Otherwise, we wouldn't pursue this order. There are all kinds of other things that we can do. But in the case I just talked about, the emergency order would be a situation where the person's obviously displaying characteristics where we believe that they're absolutely an imminent threat. They have access to firearms, and that would be a case where we would try to use this process. All the while, though, we would be in contact with the physician through our social worker, through our city public health, or even county social services to try to avoid the situation that you just described, which two of those three outcomes are really bad, I would agree. All three are not good, but two are especially bad. But what we know, though, is, in looking at some other states, that not having this tool, the current situation is not good either. Far too often our officers are going there after someone has used one of those firearms that is in close proximity to them. They're in a clearly unstable mindset, and they use the weapon on themselves, more often than the mass shooting scenario. But we also know, in looking at some of these mass shootings, as that those people were also very unstable. And there were some flags there that could have potentially avoided those situations were there to be laws like this in place in those places. Because as we've read in the media and those of us who have heard the actual debriefings, there are clearly indicators in the past that were they to have been paid closer attention to, some of those situations might have been avoidable.
Chairman Limmer.
I'm glad some of the answers have been relying on a 72-hour hold that's available under Minnesota law. If we dig too deep into that, you'll begin to see that Minnesota is what I would consider woefully behind in resource when it comes to mental illness, something that perhaps we can deal with another day, soon. But nevertheless, the other question I did have is, could this provision, could this policy be abused? Could there be a false accusation? Perhaps in a post-divorce argument between former house and wife, where a former husband would say, "My wife is a nut. She threatens me every time I come over to the house to pick up the kids. She's got guns in that house." And the process takes the guns out of that house, and now that woman is defenseless in her home from perhaps another threat, and that might very well be the former husband. I think we have to be very cautious in how we write this bill. And has there been any thought about how this bill could be abused on perhaps just the word of a relative saying, there's a problem in the house, that's the person, they got guns in there. And only to make that individual in the house vulnerable to a potential attack.
Representative Richardson.
Thank you, Mr. Chair. Thank you, Senator Limmer, for the question. And we have thought about the potential for abuse, and we know that there's potential for abuse with any law. And one of the reasons that we removed family members being able to directly petition was because of that issue. And so it would require that law enforcement actually undertake its own independent investigation in order to start the petition of an order with a city or county attorney. And I mean, I think getting back to the root of the issue, can people make frivolous phone calls to the police? Yes, they can. And I'm assuming that you get those from time to time. And I know just within the last year and a half, looking on social media, I've seen lots of frivolous calls to police that have been on video as well. And so that's something that police are currently dealing with right now. And with the intent of this language, by allowing only law enforcement or a city or county attorney, it gives that opportunity to do the due diligence to say, does this really meet the standard of risk?
Chief Potts, and I will say, Chairman Limmer, when I first was learning of House File 9, I had some of the same questions, particularly as I interacted with rank and file peace officers. So I know that's been part of the conversation as the proposal has been constructed. But Chief Potts, to this issue of I don't know if the word is frivolous, but I'm sorry, false accusations, not having our police departments be led into something that really they shouldn't be led into, et cetera. If you can share your thoughts and your understanding of how the bill is constructed. And practice, probably more than anything else, relative to mitigating that kind of potential mischief and damage.
Yes, Mr. Chair, Chair Limmer, that is an area that we had quite a bit of discussion about in the early stages of the development of this bill. I think it was mentioned that it initially allowed for family members to petition, and that was changed for this very issue, is to look at those cases really closely. Our law enforcement agencies have the responsibility to really try to figure out what is the motivation for doing this. Is it because they're very concerned about what threat exists relative to this person's level of mental health status and their access to firearms, or is it some other motivation? And the law enforcement has to work through that and make sure that that they're convinced before they would bring this or petition forward that it's for the right intentions. And so Representative Richardson kind of outlined how we went through that in the early stages, but I'll also point out Section 8 of the bill, page 12, lines 12.25 through 12.29 do classify false information or harassment as a crime. And, when the law enforcement agencies working through this, they'll be, again, trying to clarify really what's the intentions of the person that's bringing this information forward. And if there's false material or false statements or information there that lead the officers to believe that their motivations aren't true, that this section does exist for that purpose.
And we do have a few other members as well. I just want to comment very quickly on another point, Chairman Limmer. I think it's absolutely fair to ask the question about what interventions may be available and perhaps can be triggered, complemented by this kind of provisions to provide people with help. It sounds like there's some learning that's happening across the country in this regard, but I suspect, Chief Potts, that if pressed, you might say, you know, we don't have the full array of resources to be able to do that high level of collaboration consistently, you know, with our public health, other interventionists, intervention agents consistently and, you know, to cover all our constituents. And I can tell you, Representative Limmer, or Senator Limmer, that in the House bill, we do have a few provisions that are getting at that nexus with mental illness and public safety and policing. It certainly isn't enough. I think our state has consistently struggled with that. We do have some proposals. I look forward to working with you to see if any of those might have some legs going forward in the next few days. We do have a few other members, Representative Zerwas and then Representative Moller. I'm mixing up my senators. I'm sorry, actually, a long time ago. Let me go to you first because it's been a while and I just didn't write it down. Please.
Thank you, Mr. Chair.
Okay. Senator Johnson.
Thank you. So I just want to go back to the bill again, Section 3 with the extreme protection orders issued after a hearing. One of the concerns that I have was addressed initially with some questioning by Senator Limmer with the safety of the officer going to that home. The other concern that I have there is if the respondent complies with the order and turns over all their known weapons to the officer, to the officer, whoever is coming to get the weapons, or they're turning it in, but without some sort of universal registry or a home search, we wouldn't be able to determine definitively if all the weapons of that person, the respondent, were taken. So my concern is, would this be a basis then for obtaining a search warrant for the home, and almost as a matter of course that would be issued in order to ensure all the weapons were taken from that home? And if that's the case, would this be a way of circumventing, of law enforcement actually being able to circumvent some of the Fourth Amendment protections in finding, you know, maybe somebody would set this up to be able to figure out a way to get into a house, and maybe there's a known drug user or some other infraction of the law and they haven't been able to figure out how to get into that house. Could this be used as a way of maybe opening the door to that house to do a search? If you could just address some of those. I know it's a little obscure, but just kind of figure, if you could address a couple of those issues, I'd be happy.
Sounds like a question for you, Chief.
Mr. Chair and members, the first one I think you mentioned was, if I can go back and try to handle them in order, the officer safety issue of retrieving the firearms.
Right.
So we tried to cover that a little bit in some of the earlier responses in really working at developing an approach to this that follows kind of best practices with the states who have had this in place for a while. Now, there could be a scenario where someone is not willing to cooperate and peacefully surrender the firearms. And I'm guessing that's the scenario that you're talking about, where there could be the most, you know, the most significant officer safety issue. And what I can say to that is, you know, law enforcement officers unfortunately have to deal with people who aren't cooperative quite frequently and have learned and developed abilities and you know, systems for dealing with those. I don't see this being any different. The known here is that we know that this person owns some firearms, and what we have to do is figure out a smart way to separate that person from the firearms. Now, Representative Richardson mentioned some things that other states are doing, where they're not going to the house at 2 o'clock in the morning with the SWAT team. They're not trying to do a surprise tactic that might have been the way it would have been handled quite some time ago, but really trying to be smart about how you do that, working perhaps with the family and arranging a meeting. And we have trained de-escalation and negotiator officers that can get involved in this if we need to, and work through those situations very smartly, depending on the circumstances. I'm absolutely confident that the law enforcement officers in Minnesota can handle these situations. Are they going to be difficult at times? Yeah, yes, they will, but that goes with police work. But I'm confident that they can handle these situations peacefully. I think we have great police officers in this state, and they've been trying to, deal with situations like this for many years and have gotten very good at that. The second part was, could this be used as maybe an alternative to a search warrant to get into the home of someone who's in the business of dealing narcotics? I cannot see that as a scenario. I think you'd have to really be that scenario. I just cannot see how that would play out, where the officers are looking out for what this is intended to do is separate someone from their firearms because they're an imminent threat based on observations or what other people have seen in terms of their mental health status. I just don't see that as a scenario that is going to come into play where officers would try to use this as a way to circumvent the search warrant process because they don't have enough evidence. I understand the question. I don't see that law enforcement officers in the state of Minnesota would be misusing a tool like this in a situation like that.
Senator Lang.
Thank you, Mr. Chair. And this is more of a scenario-based question. The thing that keeps popping up in my mind as I've been going through this bill, and Representative Richardson, I'm guessing I'm just curious about what the process an individual would be afforded to defend against some of these accusations, that were proven on a reasonable ground. And, say, for example, I left on a Friday afternoon, and that Friday afternoon, the emergency extreme risk protection order was issued. I think we talked about a couple different areas where it could be as little as 12 hours or possibly even less than that. So what process would be afforded to me if I left for the weekend that I would have to defend against those accusations prior to law enforcement seizing or confiscating my personal property, my weapons, my guns, all those things?
Representative Richardson.
Thank you, Mr. Chair. Thank you for the question. And when it comes down to sort of what the process looks like, it's going to really be dependent on the circumstances and also upon the level of risk. Because again, if you're talking about someone who there is a fear of imminent risk and that there is an ex parte order, and thinking about it from that perspective of you're having this hearing, initial hearing, ex parte, and then having a fuller hearing within that 14-day period. The law still requires that there, and when you're thinking about sort of the due process piece, in terms of thinking about how much time someone needs in order to effectively have notice. There are also provisions as well that would allow for, and courts do this all the time in terms of thinking about moving dates as well. And so all of those things would be available to the court as well, thinking about the notice that would need to be granted for a hearing. If you are trying to give notice to someone and you can't get in contact with them, there are also provisions within the bill that allow for thinking about that process, serving process in other ways as well.
Thank you, Mr. Chair, and thank you, Representative Richardson. And I'm glad you brought up due process because that's exactly the route I was going. And the problem with that is we're bypassing due process in this bill. The person would not have the right to hear what they're being accused of, whether it's mental health issues or some other kind of danger that someone that got the proven on reasonable grounds standard met in court to get to the defendant in this case. And I'm not a lawyer, and I've never pretended to be one. And anytime I need legal advice or anything like that, I usually will talk to Senator Latz. But what I do know is I know.
My condolences.
What I do know is that there's a Constitution in the United States, and there's a Constitution in Minnesota, and it's pretty cut and dried if anybody wants to look it up. trial by jury, rights and privileges, privilege from arrest even is in the Constitution of Minnesota for representatives and senators, believe it or not. I know it's kind of a touchy subject around here, but it actually exists. It exists still. But Section 7 of the Minnesota Constitution, due process, it's an amazing little thing. No person shall be held to answer for a criminal offense without due process of law. And no person shall be put twice in jeopardy of punishment for the same offense, nor be compelled in any criminal case to be a witness against himself, nor deprived of life, liberty, or property without due process of law. I think we're bypassing that there. The Sixth Amendment for the United States, right to a speedy trial, confrontation of witnesses. Well, that's an important thing. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, and be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, and to have the compulsory process of obtaining witnesses in his favor, and have the assistance of counsel for his defense prior to having weapons or personal property or rights and privileges removed from you. That's pretty cut and dried. Let's talk about another hypothetical that's popped up. Let's say Senator Lang has, again, had this emergency protective order placed against me, and the law enforcement is coming out to my house. And they're going to seize my AR-15s, and they seized 3 AR-15s. And Senator Johnson alluded to this just a little bit. Who's responsible if they don't get all the weapons from my house and I do something horrible afterwards? I go on a shooting rampage. Who is responsible to make sure that all those weapons are removed from the house? Ultimately.
Chief Potts.
Mr. Chair, Senator Lang, that scenario that you just mentioned, although we didn't attach Senator Lang's name to it, we talked about the scenario, and it was really what led to Section 9, which is the liability protections. And essentially, if the officers are acting in good faith, they're attempting to get all of the weapons that they're aware of, that, you know, there are times when we don't know what we don't know, but this section here provides immunity for the officers as long as they're acting in good faith.
So,
thank you, Mr. Chair, and that's correct. And the reason I brought that up is because I was approached by several police officers and several county sheriffs. That's what they're concerned about. The fact that if they go to execute well, in this case, it wouldn't be a search warrant, but a search and seizure of a private home, that they would not have all the responsibility would fall upon them. And if you left and a horrible thing happened after you did what you were supposed to do per the ex parte emergency order, I think that would be a horrible thing. There's also a couple of things, you know, and we've been talking a lot about statistics today. And in fact, we talked about some statistics. I think Representative Richardson talked about them right at the beginning of her testimony. And she talked about suicide. And that one has sparked me. I've actually heard that statistic before. And it was pretty interesting. She talked about 2 different states, Indiana and Connecticut. Indiana, I think she said, saw a 7.5% decrease in suicide, and Connecticut saw a 14% decrease. I have to ask Representative Richardson, was that statewide suicide rates have gone down that much, or was it firearms only?
Representative Richardson.
Thank you, Mr. Chair. So the only suicide rates I mentioned today were Indiana, and that was a 7.5%. And that was looking at, if I'm remembering correctly, that was looking at the throughout the entire state.
Senator Lang.
That's actually incorrect. So again, don't ask a question unless I can answer it myself, I guess. But so Indiana in particular, or I'm sorry, Connecticut in particular has rates that have increased since 2005, regardless of what firearms. The Department of Health in Indiana actually, we pulled this up just prior to the hearing, has gone from 10.9 to 13.3 cases of suicide per 100,000 people in that same time frame. So I think it's important when we sit in a committee like this and we look at FBI statistics and NRA statistics and gun safety group certificates and statistics as we go along, that we make sure that we look at the whole picture of each one of these. Suicide rates in both those states have increased, not decreased. That's all I have, Mr. Chair.
Thank you, Senator Lang. All right. Senator Latz, I think you had something on a point that the senator was raising, your colleague earlier? If not, I can circle back to you. I just saw your reaction very quickly to something. Senator Latz.
I did, thank you, Mr. Chairman. I'll just try to focus on that point, and then I'll wait my turn for the other stuff. I hope Senator Lang will accept my legal advice here.
Absolutely.
There actually is a concept in the law under the Constitution of being able to have constitutionally required due process even after someone is deprived of their property or even their liberty. We already do it in orders for protection cases where a court can issue an ex parte order for protection to require a person to stay away from a certain location, including their own residence, if they make the appropriate findings that their presence would be endanger another resident there. Usually it's in the context, well, order for protection is a domestic violence tool. And then they have a right to petition the court for a hearing afterward for a review of the circumstances to see if it was appropriately issued. We already do it with harassment restraining orders, and we already do it with driver's license revocations following DWI arrests. It's a post-deprivation due process. It's been standard in Minnesota at least since Hedden versus Dirkswager in the state Supreme Court in the 70s, I think, which was the driver's license case. So although I agree with Senator Lang that due process is important, it's not always absolutely. Actually, due process, one of the things I hang my hat on is something that I guard very jealously in the work that we do here. But the constitutional question of due process has already been addressed, and there's no doubt in my mind that what we have in this bill is more than adequate constitutional due process. Now, there might be some people who feel it's not enough due process to make them comfortable, which is a different question, but it certainly meets constitutional standards. And I'll save my other comments later, Mr. Chairman.
Thank you, Senator Latz. Representative Moller.
Thank you, Mr. Chair. I have a question, a statistic, and a brief comment. So just so I lay that out. My question is for Chief Potts, and it's my understanding with this bill that in addition to the extreme risk protective order being issued, that it would actually be information provided then for a background check so that when someone, if they were to try to purchase a firearm, then that would be information that law enforcement would have available, or a permit to purchase, that information would be available. Is that correct?
Representative, or Chief Potts, rather, I'm sorry.
Mr. Chair, Representative Moller, I'm not sure I'm tracking the question. I think the order would prevent you from being able to purchase a firearm while the order is in place.
Yes.
If that is if I'm understanding the question right, it would prevent you from purchasing while the order and only while the order is in place. Then you would refer back to the process for filling out a permit to purchase and having that process move forward.
Representative Moller.
Thank you, Mr. Chair. Yes, Chief Potts, that's what I was getting at. And also, there was some questions that were raised regarding the kinds of information that law enforcement would rely on when seeking to do the petition here. And I was looking at the language of the bill, line 232.16 to about 232, onto page 233, and it really talks about the petitioner must prove by a preponderance of the evidence, this is to the court now, that the respondent poses a significant danger of bodily harm to self or others, and then it lists a number of factors that would have to be considered by the court in making that determination, such as a history of threats, a history or threatened use of physical force, et cetera. And so my question to you is, with law enforcement in trying to decide whether or not to even petition in the first place, would you also be considering the same factors that the court would be considering when whether or not to issue a petition?
Chief Potts?
Mr. Chair, Representative Moller, short answer is yes.
Great, thank you.
Representative Moller.
Thank you, Mr. Chair. And then there was some comments made about situation of women and if an extreme risk protective order is issued against a spouse, would a woman left at the house be more at risk? And I would just say that right now women are at risk. In an average year, there are 600 women in the United States who are shot to death by an intimate partner. And a gun in a domestic violence situation does make it 5 times more likely that a woman will be killed, and that statistic's even worse for women of color. And I just wanted to bring us back to a survivor's story that was shared with me, because I think both this bill and the previous bill we discussed really get at the heart of what we're trying to do with this legislation here. And this was a woman who was murdered. Her name was Shelley Joseph Cordell. She was caring for elderly clients, and one of the adult children of one of her clients had a history of threatening behavior, which she then began to direct at Shelley. And Shelley's niece tells me that had Minnesota had an extreme risk protective order law, she knows Shelley would have utilized it because Shelley was scared. There were threatening letters that started coming to Shelley from this woman, and then dead cats began showing up on her doorstep. And every time Shelley called the police, they told her there was nothing they could do until the woman actually hurt Shelley. And that's what happened. This woman went to a gun show, bought a gun through a private sale with no background check, and then ultimately shot Shelley and her attorney at the Hennepin County Government Center, where I work now, and we have a number of security measures in place as a result of that. But I think that story really highlights the kind of situation that we're trying to prevent here. And again, as I said with House File 8, just because we can't do everything doesn't mean that we can't do something. Thank you, Mr. Chair.
Thank you, Representative Moller. Representative Zerwas.
Thank you, Mr. Chair. And question for Chief Potts. Chief, you had drawn attention to Section 8 within the bill, Subdivision 1, about false information and false reports. If you could help me read through this, Chief Potts, the way I read it, it talks about a person who petitions for an extreme risk protection order. In the first section of the bill, in Section 2 of the bill, it says a petition for relief may be made by the chief law enforcement officer, a designee, or a city or county attorney. And so in Section 8, the Subdivision 1, that talks about a person who petitions for an extreme risk protection, if you knowingly provide information that is materially false or with the intent to harass, abuse, or threaten. Is that saying that if the police chief or the sheriff does that, they're guilty of this crime? Is that, because it's talking about the person that petitions, and earlier in the bill, only the police chief, only the sheriff, or only the city or county attorney are allowed to petition. So is this penalty just for those chief law enforcement officers?
Chief Potts.
Mr. Chair, Representative Zerwas, it's my understanding that that would apply to the people providing the police with the information. Now, I understand that the bill does not allow for them to petition, but in its earlier form, the bill did allow for that, and my guess is that while it was edited or modified, that sentence just was not changed with the last or latest change where the family would no longer be able to petition. So to your question, would that refer to the police? I don't think that was the way it was written. I don't think that was the intent. I think it was in earlier versions, there were some modifications made.
Representative Pinto, to this point.
Thank you, Mr. Chair. I may be able to help clarify a bit. So those who provide information in support of a petition that are false would, of course, be covered by 609-505, which is a current statute, which actually is also a misdemeanor, though it would be a gross misdemeanor a second time. That's if somebody provides information to an on-duty peace officer regarding the conduct of others, knowing that it's false, et cetera. So this language would apply to those who petition, which would, in fact, would in this case be law enforcement or county attorney. You may remember there was an amendment brought up on the House floor. I think you may have voted in favor of it, in fact, Representative Zerwas, to increase the penalty on our law enforcement officers in these situations. But it was set at this. But those who falsely provide the information to law enforcement would be covered by the separate pre-existing crime under 609-505.
Representative Zerwas.
Well, Mr. Chair and I guess members, I'm a little bit befuddled. In House File 8, the bill we just heard, if a private citizen sells a firearm to their neighbor and 19 years later can't find the receipt, they're guilty of a gross misdemeanor. But in this language, if a police chief knowingly falsifies information with the intent to harass, abuse, or threaten someone, is guilty of only a misdemeanor. I mean, these bills are so clearly not ready to be acted upon and are so clearly disjointed. Apparently, this section was left in accidentally after an earlier amendment. We're in conference committee. We have a few days left of session. There are no budget targets. There is not a single budget bill passed. And we're spending money or spending time talking about divisive bills that aren't ready. I mean, to think that a penalty for a county attorney that knowingly submits false information to harass, abuse, or threaten someone is less of a penalty in this bill than in the previous bill. If you have an 80-year-old man that sells a gun to his neighbor that when he turns 99 can't find the receipt of the sale, would be guilty of a gross misdemeanor. I mean, the disconnect here is pretty appalling, quite frankly, Mr. Chair.
Well, Representative Zerwas, I appreciate your advocacy here. I suspect that and I'm not an attorney, I suspect that there's language in state law that speaks to the issue of police officers falsifying and misleading and, all sorts of bad behavior and conduct. We can certainly ask legal counsel to give us a review of that, but I don't think now is the time. I would say that, these bills are before us because they're meant to promote public safety. We can debate whether or not they do, and from our respective positions, we can also absolutely challenge whether they're technically written in the best way possible. That's why we have committees to do that work. But it certainly is the position of this chair of the House committee, anyway, that the reason these bills are before us is because the majority believes that they promote public safety in the state of Minnesota. Senator Latz and then Senator Limmer, and then we'll wrap it up.
Thank you, Mr. Chairman. I hope that as we're going through the language in other bills, if we decide to adopt any additional policy, if we find a word or two that we think ought to be different, or policy that ought to be different, that we'll all feel free to suggest an alternative that maybe we can find some agreement on it. That's part of the conference committee process.
Absolutely.
Mr. Chairman, I wanted just to clear up one thing that I believe it was Mr. Gosh, who spoke initially, identified as a concern with regard to a respondent being given as little as 12 hours notice before appearing at a hearing. What Mr. Gosch did not say is that if a person gets a notice for a hearing any closer to the hearing than 5 days before the hearing, the person has a right to ask for a continuance of at least 5 days in order to prepare for the hearing. So no one, and that's in the bill, line 231.27. So no one would be faced with only 12 hours to prepare for a hearing unless they chose to do so. But they'd have a right to a 5-day continuance to prepare. I want to note that the standard of proof in this bill, the preponderance of evidence, which he indicated was low, it is the standard of proof in civil law in Minnesota for proving millions of dollars of, hundreds of millions of dollars of liability in business disputes or claims against defendants. It's just our standard. Again, you know, we could have a discussion about whether it's the appropriate standard in these circumstances, but it's not unusual at all. I think it's more than adequate standard under the circumstances. I would note that there was a concern about if there was an order issued, there were only 24 hours to turn in the firearms. The language in the bill actually says, he said it could be ordered to be as quickly as 1 hour, and that's also not in the bill. The language for the order is contained in the bill. Essentially, it says, I think as soon as reasonably possible, and in any case, no later than 24 hours. So no one's going to be required to turn in your firearms immediately unless, and there is a provision in the bill where a judge could determine that there is an immediate danger of bodily harm. Even if it's not one of the ex parte orders, but they have the hearing after the regular notice, and the judge looks at the situation and says, well, there really is now an immediate danger of bodily harm, and we need to move right away to get the firearms out of the house, and then the judge could issue a warrant for the removal of those firearms immediately by law enforcement. I wanted to, in addition to what I think are very compelling statistics that Representative Richardson gave to us, Montgomery County, Maryland, recently completed their first 3 months of experience under their red flag law in October, November, December of 2018. They also, they had 201 petitions in Montgomery County, Maryland, and the court only granted 148 of them, which suggests to me that in addition, and they also allowed individual persons to file petitions. We very explicitly decided not to do that because of the concern that was raised by, among others, gun rights individuals, that, you know, a vindictive spouse or a neighbor, you know, could be, could, you know, file stuff for harassment purposes. But this also tells me that the courts are also screening these petitions carefully, and they're not automatically assuming that whatever shows up in the petition is enough to meet the legal standards for issuing the petition, even if the petition's only coming from law enforcement agencies or from county attorneys. Senator Limmer made reference to what information, or asked the question, what information would be relied upon by the court in making this decision. And I would turn the members' attention to line 232.21, where it starts a pretty substantial list of items that the court could use in determining whether an order is appropriate, including the history of threats or acts of violence directed toward another person, the history of use, attempted use or threatened use of physical force by the respondent against another person, violations of court orders, including but not limited to orders listed under these chapters here, or Chapter 260C or 518B, where you're getting into the orders for protection and so on, prior arrest for felony offenses, violent misdemeanor offenses, stalking offenses, domestic assaults, convictions for the offense of cruelty to animals, which is a very strong indicator of a person's propensity to commit violent acts toward people. A history of self-harm by the respondent, whether they're named in an existing order, such as here, or an OFP, or an HRO. So these are the kinds of factors that courts will use to determine, and we want them to be thinking about these things because they are indications that a person has some history and demonstrated risk of harm, or committing harm to others. Senator Limmer also raised the question of what if a person yells at the kids who are running across the yard, if you do this again, I'm going to kill you, you brats. Well, that's already a felony offense. That's terroristic threats, or what we have renamed as threats of violence under existing state statute. It doesn't always get charged out. Sometimes it's dismissed as hyperbole, but sometimes it's not, and that's sort of a charging discretion. But it already is a felony offense to do that. There's also a concern raised about notice here, and I want to turn people's attention to line 235.14, where actually this is the point that I already made earlier, the reasonably practicable or no case later than 24 hours in terms of notice to turn in firearms. I would note that, there was some concern raised about law enforcement and whether they're comfortable retrieving firearms under these circumstances, and that's been addressed in a lot of situations, but I just want to add, it's already law enforcement's responsibility in the case of firearms orders that flow from domestic violence convictions to retrieve the firearms if the subject of the order doesn't voluntarily turn them in. We already placed that responsibility on our law enforcement agencies, and they're the only people who are trained in our society to accomplish that, so they're the best set to do that. I would also add that there's nothing in this bill that requires any local law enforcement agency to utilize any of these mechanisms. A sheriff, for example, could simply decide that they're not comfortable with any of this and that they are, as a matter of policy, not going to file any of these petitions with the district court asking for the relief. On the other hand, there might be that one or two situations where they say, boy, we really do want to use this tool this time because we don't have any other basis for separating the firearms from the dangerous person. And at that point, they'll be glad they've got the tool available in state law if they choose to use it. So those were my thoughts, members. Again, this bill started out differently, and through the collaborative process, a deliberative process, and receiving input from parties across the spectrum, law enforcement and advocates for victims and gun owners as well, because this is not the first time that this idea has come up. We made a number of modifications to this bill, and Representative Richardson and Representative Pinto and others who were involved in drafting this to come up with what we think is a really good, modest proposal with demonstrated history in other states of saving lives, and we'd encourage members to consider voting for it under those circumstances.
Thank you, Senator Latz. And finally, Chairman Limmer.
Thank you, Mr. Chair. We've had a pretty good discussion today. The latter one is on this issue of ex parte orders in order to seize guns from those that might be suspected of the potential of doing harm to someone else. And that's a good thing to have a discussion on. I appreciated the discussion, but I do have to agree with Representative Zerwas. There are a number of issues here that deserve a little more scrutiny, a little process. I think the balance between the previous bill, as Senator Zerwas brought up regarding a misdemeanor, if a police officer made a false charge, versus a gross misdemeanor if someone 19 years after a private sale is charged with a gross misdemeanor if they can't find the receipt. I find that to be a really wide stretch, and that's what we refer to as proportionality of sentence. I don't think we're really addressing that in these two bills. or at least in comparison one with another. And this is not to say that this issue isn't going to go away. I think this issue needs to be ferreted out a little bit more. But Mr. Chair, I think our goal is always to promote public safety, whether it's the first bill today or the second bill today. I think, as I mentioned before, the question is of proportionality when it comes to certain sentences. And of course, we always try to work within our constitutional boundaries, and we've had a discussion on that. There might be a disagreement on that. But nevertheless, I'm not sure where we are going with this in this process of a conference committee. I would imagine there'll be some consideration, or at least the reason why it's in the House bill is to get a vote on it. So, Mr. Chair, I would move Article 14 and 15 to be included in Senate File 802 in a roll call vote.
Very well. Chairman Limmer moves. Let's get the right language. I'll ask counsel to help me with the correct language before us. Mr. Diebel?
Mr. Chair, members, could you repeat your question? You're looking for procedural
Just want to
guidance?
make sure I have on the record the motion that Chairman Limmer.
Mr. Chair, I wish to make a motion to include Articles 14 and 15 as found in the House version to be included in Senate File 802 of the conference report.
Does that sound like correct language?
Mr. Chair,
technical.
The only thing I would add is that the House language, which is the only.
Yeah, as described, Mr. Chair.
Very well. Discussion. Representative Pinto.
Thank you, Mr. Chair. And just a question maybe for both chairs. So I serve on another conference committee as well, and we actually had a moment another day where there was a motion made that one side felt was premature, and a vote happened, and things continued. And I guess I'm just confirming, of course, that when there are motions made along the way in this conference committee process, it's not like it actually settles anything. This is just a motion along the way, and of course, language can come back up or go down or whatever way. And I just want to confirm that it's just kind of another step in that process. Thank you.
I think that's correct. Chairman Limmer, what we're doing here is constructing our omnibus bill. I have to say, it is a bit unusual. You know, typically, conference committees will adopt their same and similars and, exchange some ideas among themselves. Part of that is to build rapport. Part of that is just a very practical element of building the bill. So hopefully, Mr. Chair, this will be the first step of many steps very soon for us, in fact, to meet our duty to construct a full bill and not just one motion in one point in time. Representative Pinto.
Thank you. And I did have one other thing just to clear something up. A separate statute, this is just a concern raised by Representative Zerwas and by Chair Limmer as well, about those county attorneys or law enforcement leaders who might bring a petition with intent to harass, et cetera. A separate statute, 60943, existing statute, does impose a gross misdemeanor on public officers, employees that act in that type of way. So essentially that in that situation there would be that gross misdemeanor. I just want to assure having the separate crime of the misdemeanor that's listed in the bill does help to make clear that Clause 2 under 60943 would apply. But I just want to reference there is a separate gross misdemeanor, so there would be that same penalty. I will note that if you have a county attorney, who as Representative Zerwas described, who files a false petition with intent to harass, it seems to me that the problems go a lot bigger at that point than simply that narrow petition. I think that we've all got a lot of problems. And I guess I maybe will just note more broadly that if the concern with the bill is concern about the conduct of our law enforcement officers and our county attorneys, that may somewhat show how much support there is among law enforcement for these two bills. And that's just an interesting angle to come at this, that this would give law enforcement a tool in the form of House File 9 and the extreme risk protection orders, and would be something that is certainly calling for in criminal background checks as well. It's just an interesting angle to come at it, because it seems to me our law enforcement leaders are telling us that they need this to keep our community safe, and I'm inclined to stand with them. Thank you, both Mr. Chairs.
Thank you. Representative Pinto, further discussion? Again, I'm going to turn to council to make sure I have the right motion before us. I'm not sure what the verb is here, and so I want to make sure that we're doing this correctly. Mr. Debo?
Mr. Chair, and one point of clarification. I believe it's Senator Limmer's motion to move both articles simultaneously, or would you look for a vote on?
Simultaneous.
So I think he.
Chairman Lesch.
Thank you, Mr. Chair. I guess I'm confused why we'd want to do it simultaneously, Senator Limmer. Is there a nervousness about voting on the background checks alone?
No, Mr. Chair, Senator Lesch, there's no nervousness about it at all.
Okay. Well, Mr. Chair, I've heard a lot of talk about responsible gun owners being able to hang on to a gun for 20 years, but not being responsible enough to hang on to a piece of paper. And I guess I would think that that article should stand on its own, but at this point, I'm not going to move to amend the motion. So let's just vote on it.
Further discussion, Senator Latz.
Mr. Chairman, I think I'd be remiss if I didn't note the irony in the comments that this is worthy of discussion and some further analysis. When I've been asking for 2 years for exactly that in the Senate and have been rejected every time. So there was plenty of opportunity to have the Senate go through a detailed analysis of the language in bills as well, and it was not granted. I'm not sure where Representative Lesch was going with the question of maybe dividing the question between Articles 14 and 15, but I'm inclined to do that. So I'd ask the chairman to divide the question.
Very well. I'm just trying to figure out how to technically do that. It's kind
I think
of
I need to move
yes.
to divide the question between Articles 14 and 15.
And then, so the motion is to divide the motion. Is this called a question? I'm just trying to find the right language here. Well, so perhaps council can help me with this.
I think
I know the intent. I just want to make sure we're technically using the right language here. This is not a typical. So, Mr. Debo?
Mr. Chair and members, I believe Senator Latz is requesting to divide the amendment. You just take up Article 14 first on a vote, if the motion, if his request is granted.
Very well, let's do that. And Senator Latz, so the chair will make the call here. So your request is that we vote on Article 4, Section 14 of Article 14 first, and then Article 15 of the House language. Thank you. So members, and there's a roll call on this. So members, we're voting on Article 14 first. The clerk will take the roll.
Chair Mariani.
Yes.
Chair Limmer.
No.
Senator Anderson.
No.
Senator Johnson.
No.
Senator Lang.
No.
Senator Latz.
Yes.
Representative Lesch.
Aye.
Representative Moller.
Yes.
Representative Pinto.
Yes.
Representative Zerwas.
No.
5-5. 5 ayes, 5 nays.
On a vote of 5-8. Yes. The clerk will give us the total from each house, from each body.
The House has 4 ayes and 1 nay, and the Senate has 1 A and 4 nays. So,
Very well. So then the motion does not prevail, and the Article 14 is not adopted at this point. And members, I believe under, as we construct conference committee, or rather a common bill among the two bodies, these motions can arise again before we adjourn. Very well. The clerk will take the roll on adoption of Article 15.
Chair Mariani?
Yes.
Chair Limmer?
No.
Senator Anderson?
No.
Senator Johnson?
No.
Senator Lang?
No.
Senator Latz?
Yes.
Representative Lesch?
Aye.
Representative Moller?
Yes.
Representative Pinto?
Yes.
Representative Zerwas?
Nay.
With 4 ayes and 1 nay, the House, and with 1 A and 4 nays, the Senate, it does not pass.
Very well. So Article 15 is not adopted at this point. Very well. I think we're done with House File, the presentation in House File 9. I want to thank Representative Richardson, as well as Mr. Gosh from the National Rifle Association and Chief Potts from the Bloomington Chief, who's the Bloomington Chief of Police. Members, we have one more bill, House File 1115, Representative Lesch, Cooperative Private Divorce Programs Established, Conforming Changes Made, and Money Appropriated. Chair Lesch.
Thank you, Mr. Chair.
1115.
I thought everyone was here for this bill, but I see everyone leaving. Thank you, Mr. Chair. By way of explaining this House file and why we put it in, I have next to me former Representative Andy Dawkins, for whom I interned back in 1997. So he's largely responsible for my presence here. If there's any blame that can be placed, on former Representative Dawkins. He's also a constituent, former constituent?
Constituent.
He's a constituent, yeah. And has been working on this for years, along with a credible and thoughtful section of family law practitioners. It is opposed by the family law bar, as has been, I think, every reform that we've passed since I've been here anyway, has opposed any reforms we've had. And many of them, most of those reforms are now embraced by the family law bar, I would note. But by way of I guess, offering the details of it, I'd leave that, if we could, to former Representative Dawkins.
Representative Dawkins, welcome back.
Mr. Chairman, members, 15 years in the legislature, 30 years as a lawyer in private practice with a substantial divorce law practice, 6 years as a child support magistrate, now retired, playing softball in the mornings, and I recommend it. The first thing I want to say is that I'm glad I have everyone's attention, because I've been sitting through this conference almost every hour, and I've listened to the crying needs that are out there, the legal services, public defender, public safety needs that we have. This bill is a gift horse to the legislature with a budget that will help the state by $3 million a year in the out years, okay? Now, I started working on this in 2014, and the state Supreme Court told me that there were 15,628 family law divorce filings in 2014. I also looked at how much it costs the court system for each case that gets filed, on average. You take the whole cost across the system. And it's $754. There's a user fee of $350. That leaves $404 that comes out of this budget in here that goes to the judiciary for every divorce filing, $404 a filing. If, and I predict, and I think that there's lots of reasons why this is an accurate will happen prediction, that half of the current divorces that we have in the state of Minnesota will decide to go to the cooperative private divorce route rather than through litigation. And if that happens, you take half of that number and multiply it by the $404, there's $3 million a year less the judiciary budget is going to need to have to do divorce cases in the state of Minnesota. It's an important bill to pay attention to, okay? I was here, and you could hear a pin drop when someone asked Commissioner Harrington, what's the #1 public safety threat in the state of Minnesota these days? And Commissioner Harrington said, domestic violence. This bill will reduce domestic violence. You don't have to spend a dime, you make money. Reducing domestic violence, okay? Because cooperation is better than litigation. Because when you are litigating, there's an exacerbation, there's an aggravation. When you have judges that sign orders that someone doesn't like, you have shootings even, okay? So I encourage people to think about this bill as, one, a money saver, and two, to reduce the violence in the state of Minnesota. If I thought for a minute that I would be someone proposing something that would increase the violence in the state of Minnesota, I wouldn't be here talking with you right now. The bill is pretty simple. It just says there should be 2 classes of divorce, those with controversy and those without. If there's not a controversy, then why should you go to court? Courts are set up to hear controversies. Representative Liebling put an amendment on in the House that is okay because it takes a go slower route. So once someone decides to go the cooperative private divorce route, they go to the Bureau of Mediation Services, they get online, they fill out an intent to divorce, but they have to wait 90 days before they're divorced, for one thing. And when they make their own agreements, their own private agreements, and they get them encrypted and they can't be unilaterally altered, and they live up to them, we've got a wonderful outcome, okay? No lawyers had to be involved, no judge had to be involved, no money had to get spent on that. But if you want, you could have gone to talk to a lawyer, you could have gone to a financial advisor, you could have done any number of things, mediator, to work that private agreement out and get it filed and encrypted at the Bureau of Mediation Services. If a couple years later you decide that you could have done it a little bit differently, but better, you can go in and modify that, not unilaterally, but both of you. It's a flexible instrument that works for the future to keep families working together down the road. Now, Representative Liebling said, because the way it was originally worded is that it was a contract that was enforceable, so that if you had a deal on child support and the guy wasn't doing it or she wasn't doing it, and you need to go to court, you could get enforced. There was a nuance there because the bill is long, because it's tricky, because of all the interface between court system that you got to do and pay. But the basic concept is simple. Representative Liebling, though, said, why not have it be, instead of enforcing that contract, if the deal falls apart and they have to go to court, do it de novo. That's a lawyer term for start afresh with all the evidence. You're divorced still. You got your divorce, but all the terms that you made privately that you encrypted are going to be reviewed by the court and maybe honored by the court and put into an order, or maybe not. It's a de novo way of looking at that. Now, I divorced Ellen Anderson, a former senator, last September. And we filled out a form online called a joint petition. We submitted it, a judge signed it within a week, and there was no screening for domestic violence. This bill is the first time in law or in legislation in the state of Minnesota that we have a screening tool for domestic violence. And we have a 90-day waiting period. And, you know, the concerns I've heard along the way here about that, oh, there's going to be this coercion aspect, that there's going to be men that are browbeating their soon-to-be exes into sign this right now. Well, you know, that happens now, okay? That happens now. We know it happens now. Is it going to be more of that happening in the future? Well, for one thing, you make your deal and you got browbeaten into doing it. You got a whole year under our current law. You can go vacate a browbeaten into agreement. So if you're talking to your lady friends and they say, you did that, you can still go get a lawyer and you got a year to come back and get that done. We also have warnings in the bill that take care of that. We still have the laws we talked about a little bit earlier that that threats of violence are a crime. You got somebody that says, That's a crime. Sign or else, or I'll shoot you.
Is there a copy?
We've got OFPs that are still around. I think that Senator Sandy Pappas, who was the author of this bill, said it best when the women's advocates against the Coalition of Battered Women and others, the economic status of women and so on, were in her office when she was chief author in this. And Senator Pappas said to them, some of us don't want to perpetuate the notion that women are in general incapable and don't know how to stick up for themselves and need judges to protect them. And she said that for those few cases, we already have cases like this where there's browbeaten into divorces. For those few cases that happen, should that outweigh the large number of cases that are going to have a better outcome for the whole family? This is a pro-family bill. You know, there's studies out there that show that people don't get married these days because of the expense of divorce. They cohabitate instead. This is really, truly get the government out of people's private. We don't get involved when people get married and they have kids and tell them how to raise their kids. Why are we doing it just because they got a divorce? We got the right laws to protect those kids if there's neglect or if there's things like that.
Representative Dawkins,
I'm done.
I love you, man, but...
I'm finished. Thank you very much. Thank you, Mr. Chairman. I'm glad we've had my chance. Thank you very much.
Thank you.
You've never said that to me.
The week's not done.
I love you, man. Very well. We do have someone who wishes to testify in opposition. And again, my hope was that would be 3 to 5 minutes, but obviously, let's just move as quickly as we can. So, Mr. Carlson, welcome.
Thank you, Mr. Chair and members. My name is Joel Carlson. I own a legal research and government affairs business here in St. Paul, and I'm here on behalf of the Minnesota Coalition for Battered Women, a group I've represented here at the Capitol pro bono since 1999. And over that time, we have addressed dozens and dozens of safety issues that all of you have helped us with as it relates to protecting women and children from domestic violence, and we appreciate all of what you have done. I've also worked with countless victims and families that have lost their loved ones to domestic violence. And we've heard heartbreaking stories here about abuse. We've heard testimony from parents who are grieving because they have not been granted enough time with their children, and that is all heartbreaking. But many of the stories that we hear are in a vacuum. We only hear one side. We don't hear what is going on with that entire divorce. And so we've heard a lot of stories here that tear at our heartstrings, but even having done that, MCBW has been active in many family law issues over the past 20 years, and we do so because at the time of divorce is an extremely lethal time for women and children when they're leaving a spouse. You know, I was here, Representative Dawkins, on Saturday too, and I heard Chief Harrington talk about domestic violence being the #1 crime issue in Minnesota. And I appreciate his focus and his honesty, but despite that truth, you need to know that MCBW has come to the Capitol on family law issues and has supported many of the changes that have happened over the last 20 years. Whether it's the floor of 20% parenting time, this misperception is that 25% is what you get. That's not what happens in family court. You start out 50-50. The lowest your parenting time can be in most circumstances is 25%, but you don't start out at 25%. You start out equal going into court. And the misperception that you start at 25, I think, is unfair. We worked with Steve Smith to develop income shares and share income models with parents, and we supported that. And we supported all of the changes in 2015 that are still being implemented in court, with the one exception, and that was the change of the best interest factors for children. They added a 13th interest as it related to what is best for parents in our estimation as opposed to what's best for kids. But we supported all of that. So we don't oppose everything that is proposed in the family law area, but we do have concerns with this proposal because getting divorced by the Bureau of Mediation Services is just a bridge too far for us. And I'd like to just briefly go through the bill, Mr. Chairman, which is on page I have it as Article 21 on the House side, and I'd like to just mention a couple things about the bill. You know, as we're looking at this bill, you need to understand that as soon as people sign their name on the form online developed by the Bureau of Mediation Services, the Bureau shall issue a divorce decree. No review, nothing to look at. They shall issue, and that's what it says on page 264. And when you look at how this system is set up, it is completely problematic for people who have conflict. And some of the provisions of the bill that I'd like to highlight, that I'd like to highlight are also concerns that are shared by not just MCBW, but the MSBA family law section, the real property section of the MSBA, and the child support enforcement officers that also have grave concerns about this bill. So after they shall issue your divorce, it can be entered into court by the action of the court administrator. And it says on page 266, without court approval or review and without obtaining a judgment or decree. And that judgment or decree is important because that's how you obtain many of your rights through a divorce, whether it's enforcing your child support or what happens with your real estate or other rights that you get when you are divorced. So no court intervention at all. You may have to go back to court on page 266 on lines 28 to get a real estate disposition. So you're going to have court involvement. If you own a house, you're going to have to go to court. That's just the way it's going to be. Not to be completely picky, but I actually have issues with what they describe as the intent of this. They say that court intervention is adversarial and cumbersome and you can't control the schedule. And quite frankly, in 90% of the divorce cases in Minnesota, that's just not true. 90% of the divorces in Minnesota happen without any court intervention except for reviewing the consent and decree. That's it. And so I disagree even with the purpose for the bill. Now, it also says, and I disagree with these, that the benefits of this, the benefits are that no one will see it, no one will scrutinize your decisions, and it's a completely private process. Now, think about that from the eyes of a battered woman. Isolation, not hearing from anybody, secrecy. Those are the hallmarks of family abuse. These are not benefits when you're looking at this process as a battered woman. Mr. Chair, members, if you look on page 266, if you are feeling pressured to enter into this process, you might want to consider not doing it. It's not an automatic default. You should just be out of the process if you're feeling pressured to do this, but it's not. And they advise you to get professional service that the Bureau of Mediation Service can give to you, but they don't tell you where they're going to get that advice, who it's from, and where they're going to obtain that information. They say on page 270 that once you're done, no one will review or approve the agreements you have set forth. Those are troubling terms for a battered woman. They also say that you may want to seek outside help if you don't know about retirement accounts, if you don't know about real estate. You have to get outside help. If you don't know about a trust. You know, if you're in a manipulative, abusive relationship, Mr. Chair and members, this is an extremely scary process. I'll jump ahead to the child support section on 271, Mr. Chairman. I'll finish up on this.
When he asked me to.
you threw all the groups onto my shoulders, Mr. Chair, so I'm trying to get them all, I'm trying to get all their points across. Child support, Mr. Chair, on 271. There are strong objections to this. Number one, because it lacks judicial oversight. There is not a support order to enforce your child support obligation. And the child support enforcement officers have no standing to seek an order to enforce child support because this can only be opened up by the parties themselves. And if you look on page 272, they tell you it's a caution. If they don't pay, you might want to take care of it right away because the court may not order the payment of arrears. That's what this gets you. I do want to make one last point, Mr. Chair, and it gets to the DV screening process. And that is on page 275. Now, in this completely confidential process, which is online, they tell you to read this screening, and it says if you feel pressure or intimidation, if you have serious doubts about your spouse's willingness to reach an agreement that it will be in the best interest of your children, if you fear physical harm, if you're told not to discuss this with anyone, you probably, this isn't the process for you. And they tell you that no one will record what you say, no one will record your answers. And so even if you answer yes to all these questions, you're not automatically defaulted out of this process. That is just wrong. And that is why we have such strong objections to this process because of its impact on battered women. And if you don't understand the dynamics of domestic abuse, you need to know it's not just a black eye or a broken arm. It is a system of control and intimidation and isolation, followed up by violence if you don't do what you're told. This is a disaster for women who are battered in the court system, and we urge you not to adopt this House provision. Thank you, Mr. Chair. I appreciate your indulgence.
Thank you, Mr. Carlson. Questions, Representative Moller? No? Questions, comments? Representative Pinto. Good gosh, I've been sitting too long. Chair Lesch.
Mr. Chair, without going into great detail on everything that Mr. Carlson said, I need you to keep one thing in mind. Now, Mr. Carlson is an excellent lobbyist, and he also lobbies heavily on court matters, civil law matters at the Capitol here, and does a good job at it. You just heard him say that because 90% of divorces aren't litigated at trial, there really aren't any problems with them. I'm paraphrasing for him. But the suggestion that 90% of what's going on right now is agreed to without conflict. Everyone in this room knows that's not true. Yes, many of these divorces that are either bad situations or good situations can go to trial for one reason or another. But all of that nastiness, all of the finger pointing, all of the accusations that make it almost impossible for two people to jointly raise a child happen in that process leading up to trial in those 90% of cases. It ruins relationships. And for those of you who do practice family law or have seen family law or have been divorced, you know the arc of what happens. Of all the horrible things that happen in a relationship, whether they include domestic violence or not, there's an arc until it gets really bad, until one person says enough. And thankfully in Minnesota, we have no-fault divorce. So despite resistance to that reform, folks finally agreed, you know what, we shouldn't have to make you show cause to get divorced. So there's that arc to one person saying, you know what, forget it, I'm done. And then they have to reach some kind of agreement. Now, if you are a victim of domestic violence, you are on a completely separate track. You are not forced to go through mediation. You are not forced to go through any of those things. And in our process, all the language that you heard Mr. Carlson cite, it's for that reason.
The reason we're saying, by the way, there's not going to be any other eyes on this, because if you have any other issues, if you have any fear, any concerns, check the box, you're out. You go through the straight-up litigation process. And then once you reach that comity, if you can reach that comity with your soon-to-be ex-spouse, which is a really difficult process, that's a really hard part, then you get to the litigation part. Then you get to that 90% of cases that Mr. Carlson was talking about. And every time you turn around, there's another reason for you to forget about that agreement. How difficult it was for you and your soon-to-be ex to reach that agreement, that's out the window. Because around the corner, there's another motion saying that you're a bad parent. There's another motion to say that you were a bad spouse in one way or another. And these feelings are all inherent in both sides. Both sides, in almost all cases, feel aggrieved. So it's really easy to bait a person to go down the nasty route. And it's an industry. So I just need you to remember that the suggestion that somehow in 90% of these cases, it's not a problem, that's anything but true. It's a terrible, terrible process for anyone to have to go through. And I'd ask, if I could, Mr. Chair, to have Mr. Dawkins address some of the misunderstandings.
Mr. Chairman, members, it would only take 30 seconds, but I don't even need it. I think that people understand what we're doing here, and I appreciate Representative Lesch giving me another chance, but I think people understand what the issue is, and I want to thank John for helping me on this. Thank you.
Thank you. Seeing no further questions then, thank you, Representative Chair Lesch and former Representative Dawkins and Mr. Carlson.
Thank you, Mr. Chair and members.
Members, that concludes the agenda for today. We're like every other conference committee, Mr. Chair, just sort of waiting to see what happens with folks upstream from us in terms of targets. And in the meantime, hopefully we have a better understanding of what, at least what's in the House bill. We can certainly have a conversation about the Senate bill if we have that time as well, but I leave that to you. Since you'll have the gavel tomorrow, I look forward to staying in close touch with you. Members, until such time, then this committee stands adjourned.